Bonjour à toutes et à tous. Merci.
Good day, everyone. Thank you for being here. We will now begin the meeting, which is the 42nd meeting of the House of Commons Standing Committee on Public Safety and National Security. Before we resume clause-by-clause consideration of Bill C-22, I would like to ask the committee to consider the supplementary budget, which the clerk distributed to members recently. This is a budget that lays out estimations only, and the committee may therefore spend less on the study. Any funds that are not spent by the committee will be returned to the liaison committee. You have probably already had the opportunity to review this moved budget. Are there any questions on this proposed budget?
Est-ce que le comité
Is it the committee's pleasure to adopt the budget? Very well. The budget is adopted, which allows us to move to the meeting pursuant to the House's order of reference of April 20th, 2026, and the motion adopted by the committee on April 30th, 2026. The committee is meeting as part of its study on Bill C-22, the Legal Access Act. Mr. Ramsey. Yes, thank you, Chair. Look, given the importance that the government gives to Bill C-22 and how it has confirmed its willingness to deal with this legislation before the House rises for the summer, and considering how impatient the institutions that are responsible for keeping the peace are, and given how slowly work has been progressing, I would be very grateful to you if the necessary resources could be provided, for example, in the form of extended sitting hours, if we would be able to see to finishing off this work by the end of the House's sitting. Mr. Caputo.
We already are having extended sitting hours. Last time I checked, I think that we are currently sitting for 4 hours. I'm not sure how fair it is to the staff or to other people here. The reality is that the extended sitting hours were necessitated by ramming this bill through. And we had witnesses, often 3 experts to a panel, and then we couldn't even hear from those experts. The reality is that the Liberals have tried to ram this bill through, especially when it comes to Part 2. The government, and I wrote a letter to the Minister of Public Safety today that has been publicly released. Law enforcement has spoken about 2 parts. There is Part 1 and there is Part 2. Conservatives are prepared to pass Part 1 as amended. I believe if my colleague, if I'm prepared to take my colleague, Mr. Ramsey, at his word, which I am, then we can get Part 1 dealt with before we rise. Conservatives will amend Part 1. I believe we should amend. I hope that we will find common ground on some of our amendments. I think that among the Bloc, the NDP, and the Conservatives, you see a similar thread that is running through. So if the whole point of this exercise is to get the bill right, and we do take what Mr. Ramsey had to say, and law enforcement wants what's in this bill, I would hope that they would want part of what is in this bill. My exhortation and my suggestion to the government, and I would love to hear from the witnesses on this point, and I know that they can't opine outside of questions that are provided to them, Mr. Chair, but the reality is that I think we can give them Part 1, and I believe that law enforcement has asked for Part 1. And then the government can go back to the drawing board on Part 2, or we can have further study on Part 2, or whatever it is. But I haven't heard from the government that they are prepared to accept Part 1. We will give them Part 1. I want to be unequivocally clear, so long as appropriate amendments are made to Part 1. And I am really puzzled as to why there has not been agreement to say, you know what, Conservatives and Bloc, let's get through part one. Let's amend it. Let's look at that standard of reasonable grounds to believe versus reasonable grounds to suspect. Split that off. In fact, I had a motion in the chamber today to divide this bill into 22A and 22B. If law enforcement wants part one, if one of the issues we have is the confirmation of subscriber information and a streamlined process for production orders, which means that there's a court order, can somebody tell me why we wouldn't give that to law enforcement sooner than later if we can come to common ground, which I believe we can, notwithstanding that we still have to go through the process. If we can get through that, why wouldn't we? Wouldn't we? In fact, I don't know, Mr. Chair, I hope I'm not jumping the gun here. I'd love to hear from the officials whether they would take part one if we could get it passed. I would love to hear from the officials.
Unfortunately, that's not for them to answer at this point, but your points are well understood and well noted. Thank you, MP Caputo. Madame de Bellefeuille, vous vouliez intervenir aussi?
Ms. de Bellefeuille, would you like to also take the floor? Well, Mr. Chair, I would just like to raise awareness for our members. We have been working on this bill, and in my view, spending 4 hours working on a very technical bill with interpretation in our ears, no less, it is very demanding work. And I know that my colleagues around the table do want me to participate and do want for me to be able to understand. But listen, I really want you to put yourself in my shoes and imagine if you had to listen to interpretation for 4 hours. So as a matter of respect, I hope that the Liberals do not wish to make us sit until we're exhausted, until midnight, because I would consider that that is a decision that does not respect me. I am the only unilingual francophone here who has to work with full-time interpretation in my ear. So that's what I would have to say to my colleagues. I am ready, but that is an issue that needs to be taken into consideration. And here's something else. I would like to add my voice to Mr. Caputo's. So I think that the Privacy Commissioner should be here to look at how our amendments are being done and how they are being challenged by officials. I want to hear his point of view and give him the opportunity to explain himself. I think he should come in for half an hour, for an hour, to re-explain to us, Philippe Dufresne, why he thinks his proposals are so important. So why not invite him back for a short time to include him in the dialogue? I think we need to include him in this study, and we haven't had the opportunity to do so. And in my view, this witness has not been able to reply to what the officials are saying against his recommendations. So I am, as I said, prepared to collaborate, but also please take into consideration what I said. Thank you very much. Those limitations have been duly noted, which now brings us to the work before us today. And 4 hours have been allocated for us. There is much work to be done, not much time to do it, so we will endeavor to be as efficient as we can as a team. I will briefly introduce our witnesses, whom you already all know. So from the Canadian Security Intelligence Service, we have Ramzi Nashev and Juanita M., also from CSIS. Next, from the Department of Justice, Kimberly Gibner and Normand Wong. From Public Safety and Emergency Preparedness Canada, Richard Bilodeau and Shannon Heigl. And we also have from the same department, Fenton Ho. And from the Royal Canadian Mounted Police, we have Richard Burchell and Aaron Gilk. Those are our witnesses. And last week, at the end of our most recent meeting, we ended on Amendment BQ3, which had been sub-amended by MP Mantle. And the sub-amendment by Mr. Mantle was translated and distributed by the clerk, and that is where we will be resuming today. Are there any other interventions to be made in regards to the sub-amendment? Mr. Caputo.
Thank you. One housekeeping issue. Just want to double check. So far, do we know whether we have all the briefs that have been submitted at this point?
You have been sent, I believe, would have been last Friday, an update of the state of translation of the briefs, and it would have changed obviously since then.
Okay, I just double checking. Thank you very much. If I could be on the speaking list, if I can move on, could I speak on the sub-amendment here, please? Yes, thank you, Mr. Chair. I would like to ask particularly, well, I would like to ask the whole table about this. You heard my initial monologue, if you will. I won't call it a soliloquy, but it did talk about Part 1, and we are talking about sub-amending Part 1. And within this whole issue of getting through this bill, I think everybody here of the officials would agree that lawful access has been an issue that has come before Parliament many times. Most notably in 2014, I believe. It has now been 12 years and the internet has changed substantially. I'm not going to ask every person to go through this one more time, but my impression is that from an official's point of view, speaking objectively, there is a need for lawful access. That's why we're all here. That's what we have been told. That's why we had a number of people from your agencies come to committee and tell us we need the powers that are in this bill. Where we have parted company, obviously, is the precise powers that are in the bill and whether those should be granted in the form of legislation, whether those should be tweaked or not. At the end of the day, it has been very clear from officials and from witnesses that crime, current states of crime, and the evolution of technology requires new tools. There's no doubt, I think, about that. Where I think we haven't gotten into the meat and potatoes is into the why. As in, we've been told, look, we want to catch terrorists and we want to catch predators. And it is the job of the government to convince Canadians. It is not the job of the opposition. The job of the opposition is to scrutinize and to ask questions on behalf of Canadians. And that's where I think that Part 2 has really broken down. But would any of the witnesses be prepared to say, yes, like Part 1 is integral to what we do, and these are powers that we need sooner than later? Is anybody prepared to acknowledge that?
If I can, there is no doubt that Part 1's important, but so is Part 2. Like our job as the public service is obviously hearing concerns about gaps in the system. In this case, lawful access and some of the difficulties that law enforcement and the intelligence service has in getting access to certain information, either because capabilities are not uniform across a particular sector. We've talked about the unevenness and how this legislation, especially Part 2, is about creating some consistency across core providers, for example, which would likely be telecoms in the first instance. And so it is about creating that level playing field. We've heard the concerns from law enforcement. We've developed policy options. The result is legislation that's before you today. Part 1, Part 2 are obviously, goes without saying, they're distinct parts of the legislation, but they are both equally important to solving some of the gaps that have been identified in various lawful access regimes and how they can help law enforcement and intelligence services fill those gaps. And so the legislation that's been put forward is the result of obviously years of efforts and policy and trying to achieve the balance of lawful access within the Canadian system, respecting the Charter. And that's the legislation that's before you. And obviously we're here to support you in answering questions about amendments and providing our best information and advice on those amendments so that you can make an informed decision.
And I'm mindful of that. I mean, nobody's saying that solving crime, which Part 2 aims at, I understand that. I don't think anybody around this table is saying, boy, we want more crime here. The question is about getting it right. And we have heard, Mr. Bilodeau, and to all the other witnesses, we have heard from so many witnesses, frankly, not enough time was given to them because sometimes we had 3 experts on a panel who, if you have an opening statement of 5 minutes each, that's 15 minutes. That leaves 45 minutes for questions and answers, sometimes with 3 outstanding witnesses who really we could have had one of them. So we didn't always hear from the in-depth knowledge. And I sound like a broken record, I know, but the chief issue here, I think, that we really are dealing with is we didn't get a lot of that technical information as to, we were told, we need this, and Mayor Brown touched on it, we need this because we want to catch criminals. Okay, I get that, and we get that, but how does Section 5 sub 2 relate to that? How does the ministerial order relate to that? How do the different categories of metadata relate to that? How do location for a court order? Those are all very live issues in Part 2 that I don't think we really dealt with. So, I apologize, this might not seem like a fair question, but I think it's an apposite question. If given the choice of we could have Part 1 or nothing, I assume that the officials would say we need the powers in Part 1. Is that not an accurate statement?
It's not for us to, as you noted, I think in your first question, to answer the question about whether or not Part 1 is sufficient. If we get Part 1 and we can park Part 2, that is not something that it's up for us to answer. I think my first answer stands. Both parts address gaps in the system and are important for law enforcement and intelligence so that they can help further their investigations. There have been, and we've answered questions about in law enforcement. We're here separately from us in terms of the necessity of some metadata. There are amendments, I understand, that are part of the proposal that are to be heard by this committee that address some of the issues that you just mentioned, and happy to answer questions about that and see what we can provide you with in terms of information and advice that can inform your decision.
And I get that, Mr. Bilodeau, and I'm not trying to put you in a corner here. And officials are presumed independent. I understand that, and I still know you all have your own views. And I'm somebody whose professional life, frankly, revolved around data and its existence or its lack of existence, and how that created an evidentiary chain or an evidentiary gap. Because that was just the way it went. When you had an evidentiary chain, you had a prosecution and a potential conviction. When you had an evidentiary gap, you didn't have an arrest or charges, typically. So I'm very mindful of that. The point I'm trying to get to is if Part 1 is important, and I know you can't say this, well, it seems like you can't.
If it is important.
If Part 1 is
No doubt.
important, then why aren't we passing a piece of important legislation? Can anybody weigh in on whether Part 1 would help them if it was passed on its own? Notwithstanding that Part 2 might be important as well, but if they're both important, why aren't we passing some of that which is important?
That's up to Parliament and MPs to make that determination. As much as Part 1 is important to advancing investigation, we have had real examples provided by the CSIS and law enforcement about shortcomings to advance terrorism investigations, child sexual exploitation investigations, because we don't have the gaps or fill that Part 2 fills. And so that's why I say both parts are important, because the gaps have been identified in both instances that harm the advancement of investigations and holding the people who commit those crimes accountable.
I'm very mindful of that. The reality is we've heard a lot of testimony, if we're being candid, especially about Part 2, that has left Canadians with questions, in my view. I can't speak for all Canadians, but I'm reading the Mail, I'm reading the editorials, we have media here. There are questions about that. I don't think that there are the same degree of questions. I'm not sure if I can ask the RCMP, I'll just be direct. If Part 1 was passed tomorrow, would that be of assistance to the RCMP?
from an RCMP perspective, I mean, we work within the legislative context that we're provided. So whatever Parliament decides to pass, if it provides tools for law enforcement to use, we'll do that. But as far as, you know, what that is, we don't have that. We're not part of that decision.
I suppose Chief Superintendent Burchill, that I'm going to hearken back to a lot of the testimony, which was, look, we are often going on fishing expeditions. We've got 10 service providers, and we just need to confirm whether somebody's a provider, right? Now, we're going to look at amendments within that, but my impression from hearing from the witnesses is that they said we need both parts. If they need both parts, if the witnesses and law enforcement want both parts, they clearly want one of them. And my point here to the committee and to Parliament and to Canadians is a very clear one. If part of the equation is part one, which I think we can get to common ground on, and that would help. I don't think it's a stretch for officials to say, yes, that would help us. Now, you can't say, please pass it alone. I get that. But what I'm trying to get to, and perhaps through silence we're getting there, I don't know, is why wouldn't we give you some of the powers you're seeking when we can come to common ground? On part two, we're nowhere near common grounds. The government came in, and the minister sat, I believe where Ms. Gibner is sitting, and I asked flat out, will you address encryption? And we got answers like, we're open to amendments. And now here we are, 3 weeks later, and the minister's holding a press conference, not to get asked questions, but to tell Canadians, oh, whoa, wait a minute. We're not just open to amendments, we're going to put forward amendments on encryption, when 3 weeks ago it was, we'll see, we'll do as we please. That was the gist of it. And then we hear testimony for 3 weeks, and Canadians rightly create an opinion of the legislation in their own heads. And once that happens, and Canadians haven't been convinced, as a member of His Majesty's Loyal Opposition, it's not our job to plug those holes, those gaps. So I've spoken, I think, long enough on this, and I know you can't answer the question, but if part one's going to help you, I don't know why we're not passing it and dealing with Mr. Mantle's sub-amendment within that point, and Ms. de Belfay's amendment within that point, because I think we can get to common ground. I'll leave it at that. Thank you.
Merci, Monsieur le Député.
Thank you, Mr. Caputo. Regarding Mr. Mantle's sub-amendment, is it adopted?
Oh, I didn't see Mr. Mantle's name, so thank you. Mr. MP Mantle.
Thank you, Mr. Chair. I presume everyone has now received the sub-amendment in both official languages. Just to level set, the purpose of the sub-amendment to Mr. Belfoy's very good amendment, which originates from the Privacy Commissioner's suggestion of narrowing the scope of information that could be available in a confirmation of service request. And you'll recall we had an exchange with Ms. Gibner and Mr. Wong on that, and there was some, I guess, maybe disagreement or confusion on my part or their part, doesn't matter, on whether as drafted, or at least how the list of subscriber information as described in the bill should be understood, specifically whether the types of subscriber information that were listed in the bill are just that and nothing more, or this provides some sort of illustrative or non-exhaustive list. My suggestion was to delete the word including in subclause A, B, and C of that provision, and then the advice from the legislative drafters was to not only delete the word including, but then also include the English word namely, and forgive me, I don't know the exact translation for that in the French, but to include the English word namely, so that it is a closed list, so that what is described in A, B, and C would be the list itself. So that's the purpose of why you received it, as delete including and include namely. And I just wanted that on the record so that my understanding of the advice I received from the drafters was different than my own suggestion. So I want to talk about that, why I moved that amendment a little bit. But prior to that, just building on one point from MP Caputo with respect to our officials that are here, I wanted to ask the RCMP and CSIS, could you tell me how you were invited to appear as before the committee on clause by clause?
I thought you'd. I can go ahead first. Yeah, I became involved just because of my current role as the Director General overseeing our Technical Investigative Services branch. So lawful access falls within my remit. So since last summer when they started doing the tech briefs, I've been involved from the RCMP perspective. So I just became part of the process. That's how I ended up being here. And Sergeant Gilks, I asked my chain of command if I could have Sergeant Gilks attend with me for last week's appearance and any appearances going forward because of his subject matter expertise in operations. And they were okay with that, and I think he's been a good addition for us as a witness here at the committee.
And on behalf of CSIS?
Sure. Yeah, a similar answer from our side, MP Mantle. So I'm the Director General for policy at the service. So it's been my teams that have been involved in this, and all of the policy and ledge that we move as an organization or that we participate in. And then my colleague Winita has been the senior policy analyst most responsible for our portions of C22.
Okay, that's helpful. To clarify further, so Mr. Burchell, did you ask to be part of clause by clause, or were you asked to be part of clause by clause?
I think organizationally, I don't remember being asked or asking. I was just
CMP, I guess.
Yeah, from the RCMP perspective, because I've been involved in the process since last year, I just naturally went when I was asked by Parliamentary Affairs who'd be appearing. I said I would be appearing.
Okay, so you were asked by Parliamentary Affairs from the Minister's office to?
No, from RCMP Parliamentary Affairs, sorry.
Okay, so they would have spoken to Public Safety, presumably?
Presumably, I'm not sure.
Or maybe someone proposed? Yep, sure.
I don't know the logistics about who sent an email to who.
Yeah, that's not really.
I would just say that in my time at Public Safety, have done a few of these bills, and it's common to have the people that are the operators, so to speak, so that they can, whereas we're doing clause by clause, if there's a question about the impact of an amendment, it's important to get the views of the people that actually will be on the ground using the amendments to understand the impact from a practical perspective. If we go back to Bill C-70 on foreign interference, we had colleagues from, I think RCMP, but definitely from the service.
And I don't know if CSIS, do you have anything you want to add on that?
No, just the only point I would say is there's CSIS Act changes as part of C-22. So I think both, even if there wasn't, I think we would be because of equities, but that's, I would say, a double reason why we're here. Both CSIS Act changes, which again, we, I would say, are most responsible for, but also some of the equities in Part 2 that immediately impact on our stuff.
Okay. Is it fair to say that you wanted to be here because it affects your line of work, whether it's RCMP and CSIS, and Public Safety wanted you to be here for the same reason? They wanted your expertise at the table. Is that a fair summary? It doesn't seem like there was a specific ask one way or the other, but it's sort of a natural progression from your involvement in the drafting or considerations of C-22. Is that fair?
Après?
Maybe.
The way we think we can be as most helpful is having a diverse range of experts who can answer your questions.
Absolutely. And for my part, I agree with that. I think it's helpful to have you guys here, RCMP and CSIS. again, to the RCMP and then to CSIS, it's fair to say that you're seeking these powers that are in Part 1 and Part 2, that you support them.
As I said previously to Member Caputo's, I mean, at the end of the day, law enforcement and the RCMP, we work within the legislative context we're provided investigationally. So if there's a move to put forward legislation that will give us tools to do better investigations for victims in Canada, we're certainly going to be supportive of that. But, you know, as described, I'm here to try to help give the committee responses that they require from the RCMP to make their decisions on this legislation.
So you take no position as the RCMP on whether Part 1 or Part 2 of Bill C-22 should be passed?
Well, the position, as I said, the position that I would take is we need to operate with the legislative context we're provided. And if legislation is passed that gives law enforcement more tools to do better investigations in a more timely manner for victims, I'm supportive of that, yes.
And your view is that Bill C-22 does those things that you just described?
I think the way the bill is introduced, if it were passed as it is, parts 1 and 2, it gives us timely access to data in a structured, uniform way.
Okay, thank you. And CSIS?
Yeah, nothing significant to add to that.
You agree with that assessment?
Yeah, I mean, so we've talked a bit about it today, but it isn't our job to advocate for a particular position. It's our job to give insights into our views on how to strike a balance between the things we've talked a lot about here, which is sort of tools for security and law enforcement, as well as privacy considerations. As I said before and would reiterate, it's in nobody's interest on this side to sort of be stepping into more of an advocacy role that could potentially, for example, erode the social contract that we have as sort of key agencies of the Government of Canada. So we're here to give you our insights into the work we do and how we do it and where the challenges are, and then obviously to take the will of Parliament and implement as best we can.
Yeah, that's fair, and I would agree with that. I want more insight on a technical bill like this. I guess one of the things that I'm coming to is I don't know if who at the table was here at the table in 2013, or was it 2013? I'm not sure. The exact time when Bill C-13 was considered. I think, Mr. Wong, you indicated that you've been here working on this for some time. Was anyone else here for Bill C-13? Mr. Wong, were you here for Bill C-13? Do you recall who was here on behalf of the government as during clause by clause for Bill C-13?
I don't have a recollection. I think there was probably someone from the RCMP with me.
Point d'ordre, Monsieur le Président.
Le député André?
Mr. Chair, could my honorable colleague come back to the topic, which is the sub-amendment? Yes, perhaps we could better understand this line of questioning. What is the point?
I will be coming back to the sub-amendment shortly. I think one of the points I wanted to make, building on the discussion about Part 1 and Part 2 and who has been made available to the committee, is actually the departure from previous practice when we considered Bill C-13. Parliament considered Bill C-13 in the past, and I can't take. This was in my review. Dr. Geis made this point earlier today, and I'll just read one small paragraph of his article today, which caused me some concern.
Yes, Mr. Alsfather?
Mr. Chair, the past practice of the Committee on a Bill from 2013 does not relate to the question of whether or not we should have an inclusive or a non-inclusive list, and it doesn't relate to the sub-amendment. And if we follow the practice of, I believe, the House, he needs to speak to the sub-amendment that he's put forward, not to a general framework that could be used to talk to every single amendment and sub-amendment repeatedly throughout the entire clause by clause. So I do not believe he's being relevant, and I would ask you, Mr. President, to bring him back to order.
Yes, that's part of my job, to try to help the committee members achieve a balance. As we've said earlier, there is a limited time, and we want conversations to focus on what the task is. So I would invite MP Mantle to attempt doing that.
Sure. Let me explain how this ties back to the sub-amendment. I think all of my comments thus far have been substantive. So I want to just make that clear, that I'm trying to get to some substantive discussion here. The reason I'm asking these questions is because the amendment from Madame de Belfort and my sub-amendment are directly related to the recommendation from the Privacy Commissioner, right, Mr. Chair? That was a recommendation written to the Public Safety Committee and discussed during the Privacy Commissioner's testimony here. One of the problems I am pointing out is that we do not have the Privacy Commissioner here while we are discussing the sub-amendment and the amendment, which are directly from the recommendation. And my point is to point out that that is a problem, and that is a departure. What we are engaging in here is a departure from past practice. And I want to put that on the record, that in the previous discussion of Bill C-13, officials from public safety and from justice were here, whose attendance is routine. But the inclusion of the RCMP and CSIS during this clause by clause is different. And I want to make that point, because if we are going to say that agencies that have a view or are affected by Part 1 or Part 2 of Bill C-22 should be here to provide their input, which I don't disagree with. I agree. I think it's helpful to have the RCMP and CSIS here to answer questions on this. At the same time, I think on this amendment and also my sub-amendment, it would be helpful to have the Privacy Commissioner or a representative of the Privacy Commissioner here. That is how this line of questioning relates. Is that satisfactory, Mr. Chair?
That's a view which you are entitled to make. As you noted, these are the officials that are here now. They belong to the portfolio of public security and justice. Other organizations, other stakeholders, other witnesses would be outside of the portfolio, or many of them would be outside of the portfolio of public safety, which explains why they're not here now.
I don't know why they were present in the past, or sorry, they were not present. They're present now, but weren't in the past, and that's my point. So may I continue with my?
And again, my view doesn't matter that much, but I'll just mention that until now I have observed the RCMP and CSIS providing helpful answers to a number of MPs around the room. So my subjective assessment is that it's been helpful, and that which may justify the reasons for which they are here now.
And I agree with that. My only point is to also point out that in the discussion of the amendments that we are currently considering under Part 1 and my sub-amendment, I believe it would be helpful to also have the Privacy Commissioner, which is part of the reason why we asked. And I want to make the point that we have a departure from previous practice, one that I agree with, because under the review, clause by clause of review of Bill C-13.
Point of order, Mr. Chair.
Yes, Mimpian.
Repetition. Mr. Mental has now made the same argument 3 times, which again doesn't relate to his actual sub-amendment. Thank you.
Mr. Chair, I disagree. I've laid out exactly how it relates to the sub-amendment, having experts here to provide, if Mr. Housefather can't follow that logic, I can't help him. So
What MP Housefather is apparently attempting to do is to remind me as chair of my responsibility to invite everyone to be as coherent as possible and focus on the sub-amendment and the amendment under consideration. There'll be other amendments and sub-amendments later, and we may want to avoid repeating arguments in ways that are not helpful and supportive of the work of this committee. So just a reminder that we have limited time and we want to be as efficient as possible.
I agree with that. I will simply remind members opposite that this discussion and back and forth we're having is because they chose to interrupt my line of questioning, and
The sub-amendment.
Okay, I mean, everyone can laugh or not laugh as they want. I don't really care. I have a particular view that I'm trying to express on this
So
bill.
everyone, please.
And I'm going to continue doing that until you tell me I can't. So I'll leave it there. So my point is, as I've made it, I'm going to just read the one paragraph which I was trying to read from Dr. Geis's article because it disagrees with Mr. Wong's memory of, frankly, more than 10 years ago. So it's not fair. But so Mr. Geis wrote this morning that the departure on Bill C-22 is not the presence of departmental officials from Public Safety and Justice, whose attendance is routine, but the inclusion of the RCMP and CSIS, the operational agencies that sought the legislation in the first place. The contrast with how Parliament has handled comparable legislation is telling. When the Justice Committee conducted clause-by-clause review of Bill C-13, the last lawful access bill to reach that stage, the officials at the table were the Department of Justice and the police and intelligence agencies that would use the powers were not there to advise members on the amendment. So, therefore, I think, as I said, it'd be helpful to have the Privacy Commissioner to discuss my sub-amendment, which I'm now going to talk about. So, Ms. Gibder, Mr. Wong, we had a discussion about how to interpret the meaning of the definition of subscriber information. And in reviewing the transcript of our back and forth, I was left with sort of, I guess, two different opinions that seemed to be expressed to me. So, Mr. Wong, in response to some of my questioning, you made the point that subparagraphs A, B, and C are supposed to cover types of information that the police will use, and they're described that way with examples to try and make them future-proof in terms of what other types of information, like that information, may be used to identify the subject. So when you say future-proof, that means the information we've got there could include other stuff in the future. That's the definition of trying to future-proof. In contrast, Ms. Gibner, you described the inclusion of the word means in the chapeau, and then the inclusion of the words including in the subparagraphs. So I was left I made the sub-amendment, and I was left a little bit confused. So, as any good lawyer, I went to the source. And don't worry, I'm not going to read the whole thing. But I will read a portion of it, because it's directly relevant to this. It's actually over 800 pages. So, but I won't read that. I presume, Ms. Gibner, you're familiar with Ruth Sullivan's construction of statutes. She's the authority, right? I agree. Okay. So I'll just read a couple sections in understanding exhaustive definitions, non-exhaustive definitions, and then she actually has, I was surprised at this, she has a specific section on when statute has the words means and including in it. So we'll start there. So she writes that exhaustive definitions declare the complete meaning of the drafted term and completely displace whatever meanings the defined term might otherwise bear in ordinary or technical usage. An exhaustive definition is generally introduced by the verb means. For example, in the Transportation Act, tariff means a schedule of fares, rates, charges, and terms and conditions of carriage applicable to the provision of an air service and other incidental service. This definition resembles the ordinary meaning of tariff in the context of air transportation. Nevertheless, the statutory definition displaces any understanding of the term based on dictionary definitions or linguistic intuition. So that's the exhaustive definition. Non-exhaustive definitions do not purport to displace the meaning that the defined term would have in ordinary usage. They simply add to, subtract, or exemplify the meaning. Non-exhaustive definitions are generally introduced by the word includes, or does not include, or excludes. In the following example is the definition of the word sell includes agree to sell, offer, advertise, keep, etc., etc. Non-exhaustive definitions are used to expand or narrow the ordinary meaning of terms, to deal with borderline applications of terms, or to
Monsieur le
illustrate
député
their
Manteau,
range.
pardon.
Mr. Mantle, I beg your pardon. I am no interpreter, but I do believe it must be very challenging to interpret what you are reading because it is being read at quite a fast speed and is very intense. Microphone, please.
Non-exhaustive definitions are used to expand or narrow the ordinary meaning of terms, to deal with borderline applications of terms, or to illustrate their range or applications by setting out examples. Makes sense. Okay, and then the last section here that Ms. Sullivan describes is examples where, in our situation, where we have means and then includes in the same clause. A statutory definition stating that a defined term means and includes something would be confusing, since it would imply that the definition both displaced ordinary meaning and relied on it. However, a definition that first uses means to stipulate a definition that displaces ordinary meaning and then uses includes to enlarge, narrow, or illustrate the stipulated definition makes sense and is a conventional drafting technique. In such a case, the defined term applies to anything that comes within the stipulated definition, regardless of whether it also comes within the meaning of the words that follow includes. It is not always, she goes on to say, and this is where it gets a little tricky, because there seems to be some disagreement at the Supreme Court on this. And I won't go through all of it, but she makes reference to the Entertainment Software Association case. And she notes that it's not always obvious whether a list that follows includes is meant to expand the scope of the stipulated definition or merely illustrate it. And then she quotes the majority, Justice Sabella's majority in that case, and then quotes Justice Rothstein's dissenting opinion, and I won't read them, but they're there. And so after having read that, I was still unsure, to be honest. Maybe if I had spent some more time considering it, I would be more comfortable. So what I have proposed, in my mind at least, solves this, because we're simply going to say in the current clause it says means in the chapeau, and then in each subclause we've removed including and used the word namely to denote an exhaustive list. So in my opinion, and I would like your view on this, Ms. Gibner or Mr. Wong or whoever else would like to comment. In my view, by doing so, we've made it perhaps doubly clear that the amendment's purpose is to say the items, the classes of subscriber information that are listed in that clause are exhaustive.
I'll start. You
can have this.
I would like that. So I would say, Chair, Mr. Mantle, that I would take a step back and I would remind myself that this subscriber information provides to people that provide services to the public. So it's not going to be one size fits all, which means the information needs to not be an exhaustive list. It needs to be an exhaustive definition that could have varying components or examples of it. So I would say that Ms. Sullivan said that it was a good drafting technique, like that thumbs up from Ms. Sullivan maybe, that we did a good job by putting the chapeau. It must mean information that used to identify the subscriber, and then they're giving examples of what that could look like, because, and it has to be non-exhaustive as it were, because service providers capture identifying information in different ways. And again, I am personally comfortable with that, because It is a judicially authorized warrant where police will have to be going to a judge or a justice, identifying the kind of information that they want, and reasonable grounds to suspect setting out how that test is met in order to fall in to those rubrics. So that's how I would answer the question. Mr. Wong may have further things that might help you.
Thank you. I will just add that it is a convention that we use in the criminal code, and the third one that you read off Ruth Sullivan is exactly what this is. It's a class definition, and the defined classes are A, B, and C before the including, and all the including is supposed to do is give examples of what that class covers. The issue, I think, with making it namely and an exhaustive list in the B category, you'd leave out things like IP addresses that are assigned. So important bits of information would be lost. And when I was mentioning about future-proofing last time, it wasn't about being vague. It was about not using terminology, as Ms. Gibner just said, that is inappropriate for all service providers and that may be left out. So, and I also made the comment, I think, that if we were to do something like that, make it an exhaustive list, the definition would have to be rebuilt into something to make sure that we didn't miss important bits of information that the police need to do their investigations.
Okay. I think we're getting somewhere on what, just understanding what the clause was intended to mean, which in my view sort of reinforces why I wanted to move sub-amendment. Whether you agree with it or not is, you know, that's fine. We can differ on that. Just to clarify, Mr. Wong, though, the BQ3 amendment does include IP address, so that's not accurate. And that was also included in the Privacy Commissioner's recommendation in narrowing narrowing it to a finite list of discrete identifiers. It does include IP address. It's just written out, Internet Protocol address, in the clause. So that's an important piece of bit of information, but would be included. I just want to push back a little bit on the idea that you know, if we create an exhaustive list, that, you know, we're going to hamstring ourselves in the future. I guess from a philosophical position, my view would be that's okay. That's the lawmaking process, right? Parliament passes law. You know, those who utilize it or implement it go and do so, and then the courts interpret it, and then it flows back to Parliament to say, does it need to be? If Parliament is not satisfied with the law or how it's operating, then we can legislate again. And I think there can be good faith disagreement on how that feedback, if I could describe it as a feedback loop in the legislative making process, the enforcement, and then the interpretation should work. And different laws take a different view on that, including, you know, whether there's regulation making ability or whether agencies develop policies to interpret their own, you know, there's a whole spectrum of how that. But I would say that that's a fine result. And there's no, I think you need to make a more persuasive argument to me that in this specific case, having the non-exhaustive list here and then requiring the police to give feedback to public safety, you know, to bring that through to Parliament through the appropriate channels is not the best way to do that here for whatever reason. I haven't really heard that, and the evidence I will put to you for why I haven't heard that is because at our last meeting I asked both yourself, Ms. Wong, and Ms. Gibner, if there was anything not included in this definition that you thought needed to be, and you could not give me any examples. And then I also asked Sergeant Gilks, did I pronounce that correctly? Gilks? And your response was, I think quote, I think the categories cover most of the identifiers I would look for. So the evidence that you have provided the committee is that the list is actually pretty good. It covers what we understand right now the police and public safety and ceases to need. And if in 3 or 5 years it changes, great, come and tell us, and we will Parliament can consider changes. To me, that's a good balance, because right now, without the amendment, as we've established, yes, we're talking about it means subscriber information, but the subcategories are non-exhaustive. And so more things could be included. And I think that's why the Privacy Commissioner honed in, I don't know, this is again why I'd like someone here so I could ask them. I think that's why the Privacy Commissioner honed in on this, suggesting that there's a lot of information that could be required. And it's not just that it's a lot of different types of information, it's that the different types of information that could be required attract different levels of privacy. And the Privacy Commissioner makes that point by saying, quote, depending on the nature of the services in question, such information could reasonably attract a heightened expectation of privacy. And I don't think, would you disagree with that? I mean, Ms. Gibner, depending on the class of information and subscriber information, there may be different expectations of privacy attached to that. Is that fair?
No, I wouldn't agree with that statement, right? Because the analysis, again, I want to take a step back. When you were asking about the Privacy Commissioner and what we have done here as the Department of Justice, Public Safety is come up with legislation that is built in the privacy considerations. That's the Privacy Commissioner's mandate, as your colleague pointed out. That is his mandate. And then law enforcement have a mandate. And you will recall that Section 8, Hunter and Sutherland, set out that Section 8 protects a reasonable expectation of privacy, not all expectations of privacy, that law enforcement and privacy interests have to be balanced in the analysis. So we have come up with this legislation already thinking that through, and it is now with the committee to think through whether we got that calibration right. And so no, what we did when we came up with that definition is to think of subscriber information more broadly. It's not an exhaustive list because of services provided to Canada. We can't possibly identify every single way services characterize subscriber type information. And so know that the category itself of subscriber information more generally is calibrated in such a way to be targeting minimally intrusive information that provides law enforcement with basic information about services, name, address, and the things that we can think about today. My friend calls that future-proofing. So when the digital world becomes an AI world, that language might not be the exact same, but it is basic identifier information.
I'm having trouble with that. So you're suggesting that all of the information or classes of subscriber information in the definition attract the same level or expectation of privacy?
Yes, I would say that.
So how would you reconcile that with the Supreme Court saying that, for example, the ISP attracts a high level?
What the Supreme Court of Canada said, just again, taking a step back, you will recall that before Spencer, before 2014, subscriber information, the Supreme Court of Canada said there was no reasonable expectation in that kind of data. So plant was the case that you might recall. So Spencer in 2014 changed the world, and Spencer said subscriber information does have a reasonable expectation of privacy when it's attached to an IP address that you can link to online activity. And so you need to think that through, government, in terms of a judicial authorization. There must be something that is, people can't do that voluntarily, which is what happened before that. And so again, that's what this legislation is before you. It is a judicially authorized warrant to obtain this subscriber information now.
So in the definition of subscriber information, your view is that name, telephone, email address, identifier that is assigned to that client, account numbers, types of services, all of that attracts the same level, same expectation of privacy.
That would be my view, and I would refer you to the criminal code where a similar provision already exists. Again, just to situate you, part of the balance that we're talking about when we say, privacy rights and law enforcement in the criminal code is building it into a criminal code that already exists. So just referring you to 487.018, which is about financial data, that might assist the committee to review that provision because it's along the same lines, MP Mantle, of what you're asking me. Like, what sort of reasonable expectation of privacy do these things have? And they list all sorts of information related to your financial information that is accessible with the standard of reasonable grounds to suspect. You need a court order. You need to get it judicially authorized. The police have to have reasonable grounds to get that. But that is the type of information that is also, I would call, subscriber information. And again, I'm just suggesting to you, because it's going to be you who has to decide, but, that financial information seems a bit more, if we're comparing, like you're trying to say, like, is there gradation, Kim, about, like, the kinds of information? I would suggest there's your marker, like there's your, anyways, I just wanted to point it out if it assists you.
No. I mean, this is helpful because I'll put one. I feel a little bit outgunned here, so but I'm trying my best. So I'll put one case to you. It's Rogers, where the court said, since individuals have different expectations of privacy in different contexts and with regard to different kinds of information and documents, it follows the standard of review of what is reasonable in a given context must be flexible. Putting that over the broader framework of different categories of privacy interests. So the sort of biographical core, I think, is one of the phrases the court has used, of personal information that can reveal their choices, their habits, their lifestyles, right? Tell me if I'm wrong here, because I'm not, it's not, okay, all right, good. I would think that some of the information in the definition of subscriber information, for example, the types of services provided, could relate to that biographical core. So in my view then, for example, sub C1, might actually attract a higher level or expectation of privacy than another part of that definition. So that's why I'm having trouble with your perspective that everything in here attracts the same expectation of privacy. Do you disagree with where I'm going on this, or are we just going to...
I understand your question, and my responses are trying to assist you. So again, maybe that, I'm not sure what would assist you, but talking to your RCMP witnesses here about the types of services that would, so again, you typically look at the types of services, and we're thinking of the the telco example, where it's, do you have cable, do you have one phone, do you have two, all of the different kinds of applications. Nothing's coming to mind that would shift or be able to answer your question any better, but if you have something that you're thinking about that we can respond to.
And I would kindly and respectfully suggest that if you do have questions related to your sub-amendment, you may want to pose them, because my subjective impression is that we are running out a bit of the topic of the sub-amendment by looking at other important issues possibly, but not focusing on the sub-amendment.
Fair. Let me bring it right back. The reason this discussion is important is because simply saying types of services provided, such as we are here, I think, as Ms. Gibner correctly stated, elicits the sort of common sense reaction of, services provided by the telco. But it's not limited to that, because we know, as we just established, that the sub-clauses are non-exhaustive illustrative lists. So it's not just the information that the telco has on you. It could be, for example, and I'll put it to you, how about its services related to hotels or an escort service that someone might have engaged? You know, I would suspect that would be different than saying, telco, do you provide them services? So I don't know, to your point, if the RCMP or CSIS have any color they want to add on that. My point is that this being non-exhaustive leaves it open that some of the information may be a lower expectation of privacy, some may be higher. And when we get to the discussion of the standard, that will also play a role in that. Mr. Burchill, Mr. Gilks?
Sorry, just to be clear, what's the question?
It's trying to understand what you think services provided, and I don't appreciate I don't appreciate the laughter.
I agree. So we need, everyone's.
Let me be very clear. If I wanted to just blow this up, I got 800 pages that I can work in. I'm not trying to do that. So
let's do that. It's a balance that we are currently achieving well. So let me come back to it.
Would information like, for example, services provided by hotels, Airbnb, escort services, that might be useful in your investigation? Yes? No?
Well, I mean, if you're referring to, well, it depends on, I guess, who is actually running the service, because we cannot serve judicial order or court order to an entity that's currently under investigation. So, I mean, if we're going to be asking about details of their possible criminal enterprise, then we cannot even serve them with something like that. We do have to take into account that the information that we're receiving in the way our investigations flow, there's more than just evidence of the offense that we are trying to collect. And that is, and there's precedence in that when we write search warrants, for example, for a computer system, we're searching for evidence of the offense, like let's say photos or emails or something like that. But we're also searching for evidence of the use of a particular device or use of an account or something like that. So in terms of what can be provided to us in terms of services, a lot of the time we're trying to corroborate and trying to establish who might actually be behind or who might actually be in control of a particular, of the unknown that we are trying to establish. So, I mean, you know, and this does happen, for example, when we do write a production order and we obtain for a home service, and we do obtain that there's a second security system service that's been purchased, and we do a follow-up production order to obtain the location of that, and we do identify other homes belonging to the individuals. We do identify other operations facilities that they may actually have that they're obtaining services for. So for us, it's the importance of being able to establish not only evidence of the offense, but also potential other sources for evidence that we could write to going forward.
Is there anything you'd like to add, Mr. Burchill?
No. His example would illustrate what I hope it answers your question.
Yeah, it does, because it confirms what part of my uncomfortableness with the current clause is, which it's being left open-ended. So the scope of that subscriber information could potentially be quite broad. Therefore, there could be different privacy interests at play. I don't think that's the best balance, I'll say, between providing law enforcement the right classes of information to identify what services we're providing, and then potentially going to the next step of getting the production order, but the protection of certain privacy interests that Canadians, in my view, reasonably have. So to summarize, that's why I think that this sub-amendment to create a exhaustive list is necessary, and I think that's in keeping with the Privacy Commissioner's recommendation to narrow the list of subscriber information to a finite list. So thank you, Ms. Gibner. Thank you, Mr. Wong. Thank you, Mr. Birchall, Mr. Gilks, and Mr. Nashef for your comments here. And I will leave it there.
You- Your points have been well expressed and well understood. Madame de Bellefeuille et MPR.
En fait, je voulais juste m'exprimer.
In fact, I just wanted to speak to the amendment, Mr. Chair. Here's what I found. My amendment is a reasonable compromise on Clause 4. But I find that if we remove namely, it becomes too restrictive. And therefore, it would be beyond the purview of the Commissioner. So I wish to convey that I will be voting against the amendment, and I would like to re-debate my sub-amendment because I did not receive a satisfactory answer as to why we cannot adopt it and therefore deal especially with the matter of services provided. That is what is particularly urgent to me. So I would like for us to discuss the sub-amendment, Mr. Chair, and then I would take the floor.
S'il vous plaît.
Mr. Au, please.
Mr. Chair, well, I will speak directly to the sub-amendment. You know, I'm in support of the sub-amendment. But, you know, before I go on, I have to share some of my observation, and I think I want to seek your guidance in the process. I think we're going in circles, and I wonder whether or not we can move fast enough to produce a workable, acceptable, and balanced piece of legislation for the use of public safety. My feeling is that right now we have opinions from only one side. Now, we are talking about trying to get a balance. I know that this is what we are supposed to do. We have a piece of legislation in front of us. We have different views. We have people who are in favor, and some people who are a different group might say, no, you know, this is going too far. But what I observe here is that even though our witnesses said that they are not here to advocate for the passing of the legislation as is, actually they are, because, you know, they are going to be the the user, right, the consumer of this legislation if it's going to be passed. And I can understand that from this perspective, they should have the more the better in terms of authority, power, and convenience. But on the other hand, you know, we receive lots of submissions by civic liberty groups and service providers. They have a very different view. They have concerns, they have worries, and then they also express the limitations they have if this bill is being passed. So what we have here today, and as of last week, you know, whenever we raise a question, we almost got a rebuttal, saying that this is not working, this is not the right approach. So this is not what I would like to have, and that's why I support the idea that we at least should have the privacy commissioner be present to answer some of the questions. Yes, you know, he made that presentation before. He also, and as like other people, their submissions that were received. However, it's different from having him present, and because new questions, new perspectives, new insights have been raised. So that's why I think we need to have a balance, you know, in opinions and people who can give us another perspective so that we can actually strike a balance.
MP Householder?
Mr. Au has been speaking for 5 minutes now, and he hasn't dealt with the sub-amendment at all. He's relitigating a motion that was defeated by the committee at the last meeting, and he has not once spoken to the sub-amendment in question. And Mr. Chair, I have to say that that is not within the scope of how we deal with clause by clause.
Well noted. Thank you, MPR.
I think my suggestion is that just be a little bit more patient. You know, this is exactly I'm coming to you. You know. No, but again, okay. Again, let me tell you more about my background. Okay, I'm not a lawyer, so I'm not going to make long speeches. You don't have to worry about that. You know, but I'm a family therapist. I'm used to it, and I'm trained to listen to both sides. That's where I'm coming from, and that's why I make the statements that I made earlier. Well, I mean, the more you interrupt me, the more I have to explain myself. Is it not the case?
So let's focus on the sub-amendment, and let's also respectfully listen what the content of that input will be.
So that's why I said that I said it in the beginning. You know, I am in support of the sub-amendment. I said that last time. We need to have a clear definition of what we are seeking for, and this is also what the civic liberties groups are asking for, and what the service providers are suggesting. So, last time I also mentioned that we should limit and be clear about what information are we seeking, and have a clear definition. So with that, I will express my opinion.
Thank you, MPR, for having done that. Est-ce que le sous-amendement
Regarding the sub-amendment to Amendment BQ3, is it carried? Thank you, Mr. Clerk. Could you please do a verbal vote?
Monsieur le Président,
Thank you, Mr. Chair.
sur le sous-amendement.
The current vote pertains to the sub-amendment to Amendment BQ3.
Mr. Housefather.
No.
Madame McCann.
No.
Madame Desrochers.
No.
Madame Dandurand.
No.
Miss Sodi.
No.
Mr. Caputo.
Yes.
Mr. Lloyd.
In favor.
Miss Kirkland.
Yes.
Mr. Au.
Yes.
Madame de Bellefeuille.
No.
Pardon, Madame de Bellefeuille? No. Yeas pour 4, nays contre 7.
Merci, Monsieur le greffier.
Thank you, Mr. Clerk. Therefore, the sub-amendment is defeated. We will come back to Amendment BQ3. Ms. de Bellefeuille, I don't know if you have noticed, but I've been holding my hand up to my ear like this because I have an auditory issue, because I'm hearing English in my right ear from my colleague, and I'm hearing interpretation in my left ear through my earpiece, and so I have to block my one ear, because if not, I'll go crazy. And sometimes when the witnesses speak too loudly, and Mr. Mantle as well, but it's not your fault. It's because you have a good speaker's voice. I just wanted to explain why I was doing that. So here's what I understood. One of the witnesses at the last sitting used a fabulous expression and talked about a fishing net instead of a fishing pole, a fishing rod. You said with the C-22, it's like we have a huge fishing net, and it'll help us to catch more criminals than if we could only fish for them with the fishing rod. When I analyze things in life, I always have a spectrum from acceptable to ideal. I always try to get close to the ideal end of the spectrum, but I am content with what is achievable. So today, here's what I'd like to say. The Privacy Commissioner was saying to law enforcement, and I understand you've been waiting 30 years for legal access, and now that you have your chance, you want the full fishing net to access your full scope, but we need to make sure that we are not biting off more than we can chew. And when I ask you the question, what will change, and lawmakers say, well, it would be like this, it would be like that, I think the privacy commissioner's role is very important. It's to restrict somewhat. And we need to specify the type of service further. We discussed this in some detail at the last sitting. And I'm interested in the type of service provided. But at a certain point, there's a limit to how exhaustive the list of services provided can be. So I would ask the question to law enforcement, but I know what you'll answer. You'll say, we need more. But if my amendment were carried, you would have access to more information to which you do not have access today. Am I mistaken, Mr. Burchell?
C'est un plus.
It would be more, wouldn't it?
Désolé,
I beg your pardon. Could you ask once more, just the last part of your question? My question is, the amendment as it is drafted, would you have access to more things than you currently do? Therefore, is it an improvement for you? Is it going to give you more access? I'm not sure how that's translated. More.
Un avantage, je sais pas.
Is it an advantage for you in your work? I'm not sure what interpretation you received in your ear. I would like to put the question to my colleagues at the Justice Department to assist me in answering. Because according to my understanding of what is being proposed in this bill,
disponibilité.
it's in regards to the availability of information to which we would have access. And we only have access to a certain specific type currently. So perhaps my colleagues at Justice could assist me with this definition of what we have access to now. Microphone, please. I'm not understanding what you're trying to say to me. Here's what I'm asking you. I'm asking you about the amendment that I'm proposing here. My amendment regarding the privacy commissioner. Even though this would be a little bit restrictive, would it still be more advantageous? Would it still be an improvement? Would it still give you more than what you currently have? Mr. Chair, you must give the floor.
Il n'y a pas de lumière.
OK. Je vais répondre en anglais.
I'm going to answer in English.
A plus because currently police use the general production order, and I think in other motions that are coming up for discussion, you're also proposing to raise the level of judicial scrutiny, the test for it. So you're actually, it goes counter to the objective of the bill, which is to provide police with timely access to data. This would, in fact, give them less than they're currently getting under a general production order. So the idea about la canne à pêche, the more precise tool, is to give them the information that is consistent, as Ms. Gibner said, with other information that's available under reasonable suspicion already in the criminal code that relates to subscriber information. So this would not be, your amendment would give them less than they're currently getting, and would even with your other proposed motions, even if it were to stay the same, it would actually give them less than they're currently getting.
Je sais pas si j'ai bien compris.
I'm not sure if I understood properly, but here's what I thought you were telling me. So the team of the privacy commissioner Mr. Dufresne is a lawyer, so I assume he's very competent. You said that he proposed amendments that would hamper your work in law enforcement. I hold the commissioner in very high esteem, and I personally find it very, very a great shame that he's not here with us in this study. And I find it very significant, the comment that you just made. I'm very surprised. You're saying that the commissioner was out to lunch, that he was completely mistaken. In Quebec, we say dans les patates, in the potatoes, he was out to lunch. He was mistaken. So does that have an English equivalent? Out to lunch, dans les patates? You know that expression, don't you? Inaudible for the interpreter. I'm not sure how that was interpreted. It's a very Quebecer expression. We have very expressive language, and so it means that he was mistaken. And I think that this is a really big deal. So you surprised me very much in saying that. I'm going to have to take your word for it, but I do have my doubts. And if the commissioner were here beside me, I would ask him my questions, and Mr. Chair, that would satisfy me. Now I will stop my questions because we're just going around in circles and you're answering me the same things. And I would really like the commissioner to be included in the debate, which would enable me to better understand what he had in mind when he made those recommendations. He tabled 8 amendments. And I have a hard time believing that his entire team was out to lunch and that he would hamper the work of law enforcement through his recommendations for Bill C-22. So, Mr. Chair, that's all for me. Thank you, Ms. de Bellefeuille. Mr. Mantle.
Thank you, Mr. Chair. I just want to follow up on that point from my colleague, and I'm going to put this back to you because I want it on the record. Mr. Wong, your view is that the Privacy Commissioner's recommendations are counter to your understanding of the purpose of this bill, and that, in fact, it's worse than that the Privacy Commissioner's amendments are redundant because you would be just back in the same situation of getting a general production order.
Yes.
Okay. I think that warrants a response from the Privacy Commissioner, so we might want to respond to that. Another question I have for you, Mr. Wong, and it's we touched briefly on you mentioned briefly the reasonable suspicion, and that there are other provisions in the code where that is used. I'm not an expert, and I didn't practice criminal law, so the standards are, well, I had to take criminal law in law school. That's the last time I touched it, thankfully. Could you just explain a couple examples in the criminal code where that standard is used? Because you mentioned that in your response, because otherwise we're just back to what you would get under the general production order, which is the higher standard. So what are some specific examples in the code that use that?
Thank you for the question. There is only one production order under reasonable grounds to believe, and that's the general production order. There are, I believe, 4 production orders currently, maybe even the specified dates. No, that's reasonable grounds to believe. So the tracking or tracing specified communications, so that's a transmission data production order. And back to your earlier question about C13, these all came about in C13. So that's 015. 016 is the production order for transmission data. The production order for tracking data is 017. And 018, which Ms. Gibner talked about, the financial data production order, that's been in the criminal code since 2004. And that includes not only your banking information, but the customer name and address, the type of subscriber information that we're talking about currently in the subscriber information production order. So all of those are under the reasonable suspicion standard.
Thanks. That's helpful. And I thought you might go to the transmission one because that's the one that I'm aware of. And I suspect we will return to that in our discussion and debate on the different standards, because I think we may take a different view on what transmission data is versus what is being proposed in subscriber information. But one of the other points that the Privacy Commissioner has made with this list, and it needs to be dealt with in the list before we get to the standard, because if the standard is not changed, then the Privacy Commissioner makes the argument that the problems with the definition will be magnified because its other portions of Part 1 rely on that definition. So the Privacy Commissioner makes the argument that because this definition will then be, because the production order for subscriber information, after you get the confirmation of service, which relies on the same definition, can be served on any person who provides service. That means that in some of the cases, service providers are going to be required to provide all, it refers to all the information in the chapeau, right? So what do you say to that critique, that this definition compounds the problem because the subsequent production order for subscriber information would then rely on the same definition? That's very expansive.
I will refer back to what Ms. Gibner previously answered, just in terms of the balancing of the privacy interests with what police need. The way that and we're not on this clause yet, but the way that the subscriber information production order is constructed, it's based on the definition that we've already dealt with, and we've tried to include the information that police need in an investigation. But the way the production order works is that the service provider would provide that information in relation to something else, and that's in relation to the phone number or the IP address that the police have obtained because they're investigating a crime.
Okay. Thank you for that. I don't think that answers the critique of the Privacy Commissioner. But I do want to reiterate and continue to reiterate, this is why I actually think like we could come to a reasonable place on Part 1, despite, I clearly have some differences of opinion on some of the amendments. But as Mr. Caputo said, I think we could come to a reasonable position on Part 1, which, as we've heard, would be helpful. And so I would reiterate that that offer remains on the table for the members opposite to consider as we move through Part 1, especially as we move through this current BQ3 amendment and the other amendments, that with some reasonable amendments here, which we're debating, we could arrive at a place, excuse me, where we could pass Part 1 and then continue clearly the discussion that needs to continue to have on Part 2. I think that's a reasonable off-ramp. We've offered that.
Point of order.
Oui, Monsieur le Député.
Est-ce qu'on discute toujours?
Yes, Mr. Chair. Are we still discussing the amendment, Mr. Chair?
And again, the chair needs to be careful, but we've heard those arguments before. MP Mantle.
Thanks. I would just remind members opposite, every time you do that, you're just going to make this longer. So, you're sort of operating against your own your own cause there. I was just saying these amendments are important, and if we can reach a reasonable position on them, I think we could pass Part 1, which would be helpful, and then we could continue discussing Part 2.
Thank you very much for that. Est-ce que l'amendement BQ3 est
BQ3, does it carry?
un vote par appel nominal, Monsieur le greffier, s'il vous plaît.
Mr. Clerk, please proceed to the vote.
Merci, Monsieur le Président. Le vote est sur l'amendement BQ3.
Thank you, Mr. Chair. We're voting on BQ3.
Mr. Housefather.
No.
Madame McCann.
Non.
Madame Desrochers.
Non.
Madame Dandurand.
Non.
Ms. Soli.
No.
Mr. Caputo.
Oui.
Mr. Lloyd.
In favor.
Ms. Kirkland.
Yes.
Mr. Howe. Madame de Bellefeuille.
Oui.
Yeas pour 5, nays contre 6.
Merci. L'amendement.
The amendment is defeated. Is Clause 6 carried? Clause 4, rather. On division. Very good. Carried on division. Clause 5. NDP 2 is deemed moved. Madam Kwan, would you like to take the floor?
Thank you very much, Mr. Chair. Yes, so with this amendment, I note that the International Civil Liberties Monitoring Group and the Canadian Chamber of Commerce have raised concerns with respect to production order thresholds, saying that, quote, reasonable grounds to suspect, end quote, is an unreasonably low standard, particularly given the Supreme Court of Canada's findings regarding high potential sensitivity of subscriber information, which, quote, has been described as narrow in scope, but in fact, it is incredibly revealing about personal aspects of an individual's life, end quote. With respect to this standard, this amendment replaces the language, quote, reasonable grounds to suspect, end quote, with, quote, reasonable grounds to believe, end quote. So doing so in all provisions regarding subscriber information production orders and real-time device tracking authorizations will set a standard that requires a probability of a crime rather than a mere suspicion before they can map a citizen's movement or demand identifying logs. I hope committee members will support this amendment, Mr. Chair, and I know that others have also advanced, actually, I think exactly the same amendment as well.
Merci, Madame la députée.
Thank you, Ms. Kwan. Mr. Caputo.
Thank you. Would, to the officials on this, the reasonable grounds to suspect versus reasonable grounds to believe, is there an analogy to be drawn with Section 495 of the Code as to the powers to arrest and the reasonable and probable grounds to make an arrest?
Point of order. Sorry, I don't mean to interrupt my own colleague here. I just wanted to clarify with the chair. Ms. Kwan made the point that there are other amendments that are similar, and I just want to get your view on if this is passed or defeated, how that affects the other similar.
That's a good question. There's no impact on the subsequent amendments.
Thanks.
Boy, I had a really good thought going there. So Section 495 of the Code, as I recall, governs reasonable and probable grounds to make an arrest, and that is based on reasonable grounds to believe, as I understand. Is there any connection between the powers of arrest versus the reasonable probable grounds to believe? In other words, are they on the same standard? Does Section 495 operate on the same standard as reasonable grounds to believe if we were to adopt this amendment, I suppose is a better way to put it?
Thanks for the question, but no, one's reasonable suspicion and one's reasonable grounds to believe. The arrest without a warrant is a big power of the state to apprehend someone. What we're talking about here in Clause 5 is the confirmation of service demand. We've provided information to committee members before that in every other country they don't need this tool because service providers say yes or no, whether or not they have information. The issue in Canada is that we have service providers that require a court order for any time they talk to the state. So the information also is yes or no, and this was changed from C2 to C22 after consultation. So the impact on privacy and a person's rights is far less. In fact, it's impacting upon a service provider just to confirm whether or not they provide service to a telephone number or an IP address. So the standards are different.
Well, I understand that, but I'm going to read. I'm not sure if I articulated my question properly, because I'm going to. Right now, we're debating the standard on which a production order should be granted or not. And if I understand Ms. Kwan's amendment, it is to take it from reasonable grounds to suspect to a reasonable grounds to believe threshold, unless I'm looking at the wrong threshold.
Chair, may I intervene? I think we're talking about Clause 5, are we not, which is the confirmation of service demand?
Yes, we are.
Thank you.
Okay, I must have missed, I must be looking at the wrong thing on my chart. I'm going to consult the amendment directly here. One moment, please.
In the meantime, we have MP Lloyd.
Sure. I believe this is with Clause 5. I was wondering if the officials could tell us what would be the substantive difference in an investigation if it were changed from a reasonable to suspect to a reason to believe? Like, what's the practical reality for a law enforcement officer in terms of time put into something that requires a threshold of reason to believe as opposed to reason to suspect?
You knew like who you were directing the question to, maybe?
Well, I think it would probably be most appropriate directed to people who are in law enforcement. But if they didn't have the answer, then perhaps some of the officials could answer.
The question is about the difference with, no,
Okay, so if I can make it, in terms of like the practical, getting a court order in order to get the subscriber confirmation, what is the practical difference in terms of time, effort, thresholds that have to be hit by law enforcement when we're dealing with reason to suspect versus reason to believe?
Okay, I think I'll start, and then I may ask my colleague if there's an operational example that may reinforce what I'm going to say. But I think the way the legislation as proposed now, the reasonable grounds to suspect is, a constellation of facts that you have possession of, and it's at the very beginning of an investigation. So you're still trying to link a criminal to a crime where there's a victim. So the confirmation of service demand is simply enough facts that you need to document that's disclosable in court to say, do you service this person, yes or no? So you get your answer, and then you build on that, and there has to be investigative work done to support what you've already found out, in addition to any other investigative avenues that you have in order to get subscriber information, to try to link somebody to the crime that you're investigating.
I understand what the purpose of the confirmation of service demand is. I'm just wondering, so what I think you're saying is that the evidentiary requirements would be higher for a reason to believe versus reason to suspect.
Yes, but the reasonable grounds to suspect for the production order as the next step is you're talking, because you were asking, I think what your point is, what's the difference in time? There's no new powers per se. It related to Madame de Bellefoy's question as well, is that as proposed right now, the production order for subscriber information is a much narrower scope that you're looking to get at the beginning of investigation, as opposed to going through the process of getting reasonable grounds to believe for a general production order, which gives a lot more information, but also takes a lot more time. So the purpose of these and the reasonable grounds to suspect is the timeliness and access to the information at the beginning of an investigation. I hope that helps, and if there's an operational example that could assist, maybe my colleague could help, but I hope that answers your question.
Thank you. It somewhat answered my question. And so what I'm, to be clear, I know there's Canadians watching this who might not understand as much, and I'm learning myself, but this is purely the reason to suspect versus reason to believe. This is the court authorization that is necessary to receive the yes or no question from the companies, the telecom companies, or the electronic service provider that is the confirmation of service. Is that correct? And then you're nodding your head, so I'll take that as a correct.
Not sure what the question is. Like you're talking about the confirmation of service demand. It's a reasonable grounds to suspect to ask that yes or no question. That's my understanding of the legislation as proposed, yes.
Is there anyone else who has a different understanding of that?
I'm not going to disagree with that articulation, except there's no judge involved. It's in the mind of the police officer. He has to have reasonable grounds to suspect before he can ask this of a service provider.
Now, is that something that's subject to judicial authorization?
No, but all of these non-warranted tools, like the exercise of an unwarranted power in the criminal code, always receive extra scrutiny when it comes to the prosecution. Anytime that a police officer acts without judicial authority or exercises those powers that usually come with judicial authority, there'll be a heightened level of scrutiny in terms of bringing the evidence forward. And as Chief Superintendent Burchill said last week, that's the last thing the police want to do is jeopardize a case. So they make sure that they have those grounds before they act.
Thank you. I'm actually a little bit more concerned now than I was when I began my line of questioning. So what accountability mechanisms are in place, because we could have law enforcement, you're saying that they don't need to require any judicial authorization when they have a reason to suspect. What's stopping law enforcement from just spamming every ESP to say, is this IP and address a customer? Or is this person a customer of you? What accountability mechanisms are in place for that?
Thank you for the question. The framework for the confirmation of service demand it's built as a back and forth between the service provider and the police officer in order to get the information that the police need. So the service provider has the ability to either respond or say they're not going to respond or change the timelines because they might not be reasonable depending on what type of service is being asked to confirm. So the scheme is built with that cooperative approach, as are all the production orders in the criminal code. They're meant to be served on cooperative third parties.
That was said earlier by yourself or one of the other witnesses was the reason that you needed to bring this forward was because there are stakeholders out there that require a court order in order to respond. But you've said that a reason to suspect doesn't require a court order. So that sounds like it's conflicting to me.
There are reasonable suspicion production orders that require court supervision. There's already an existing preservation demand that is reasonable suspicion in the criminal code that police officers use as well, and that's been there for many years. The preservation demand itself or the confirmation of service demand will not require a court order, so it doesn't have that judicial oversight. But as I was explaining before in terms of the paper that they want, it's basically for indemnity from liability. The service providers want to be compelled to do something. They don't want to be seen as being complicit with the state.
Okay, and perhaps this will be my final question, but you said that as part of this back and forth, a company may decide not to respond to a request for confirmation of service. What would happen in that case? What would be the next step in that process?
There is a scheme that allows them to either respond or object. If they simply do not respond, there is a penalty scheme that's built in as well. So,
Or what if they object?
if they object, then the clock stops, and until the matter is resolved, they don't need to confirm or deny whether or not they provide the service.
Okay, thank you.
Merci, le député Lloyd.
Thank you, Mr. Lloyd. Mr. Au, please.
Thank you. Well, actually, my colleague asked my first question, regarding, if whether or not there's a channel for the service providers to dispute or not to provide, right? You answered the question. Now, I think, again, we're talking about keeping a balance here. I understand that the law enforcers, they want more power and more convenience. But on the other hand, with other groups like the civic liberty associations and also the service providers, they have other concerns. I want to ask another question, which is about the duty to inform. So if the service provider provided the information requested, and after investigation and the law enforcer felt that he or that guy was not the suspect, is there a duty for the service provider to inform, or is there duty for the police to inform the person involved?
Thank you for the question. There is no positive duty for the police to inform, but there is an ability within the scheme to order non-disclosure if it would impact upon the investigation. So in disclosing this because they're under privacy legislation, there is a positive duty to inform your customer if they ask, if anyone's asked for their information. And to counter that, there is the ability to impose a disclosure restriction inside the confirmation of service demand. This is valid for a year. If it needs to be extended, it would have to be extended by a court.
So are you saying that in that case, if the person was not being informed, he could be kept in the dark forever?
Thank you again. Yes, I think that may be a possibility if, as we've talked about, a lot of these tools are used to figure out who the suspects are, who are the innocent people, who are the victims, and if the person's an uninterested person, the police would not follow up, and the person would probably not follow up that police had inquired.
Okay, what if there's a company, when they enter into the service agreement with the customer, there's a provision that there's a duty to inform, or there's a consent to release personal information is required. So if there's such kind of a service agreement between the company and the customer, and this would put the company in a conflict because you compel the company to provide the information. Is that not the case?
That is the case, but again, the framework allows objection based on certain grounds, and one of them is otherwise not, if you're prohibited from disclosing by some other reason, including by law. I'm not sure contractual law would override the criminal code in this case, but they would have the ability to object on that basis.
Now, if I understand you correctly, you seem to imply that the company has the right to spill or to object or to withhold information, and there is no consequence to the company.
If the company does not provide the information, does not respond to the demand, there are consequences, but there are off-ramps for that company if they don't think the disclosure would be consistent with their legal obligations, so they could object, and that's when the scheme kicks in and the clock stops, and then a judge will hear whether or not their objection was reasonable.
Okay, in that case, would it not make your legislation useless? Because you keep on telling us that It's because of urgency, the time. You need a fast response. You need the information right now, immediately, before the guy is gone. So if I'm just hypothetically, the company choose to delay by not responding, and there may not be a consequence. Then, so what is the use of the legislation? Because you cannot compel. You wanted to ask for information fast enough. But if there's such a leeway, if I can call it, for the company to delay, what's the use?
Thank you again for the question. Going back to one of my previous responses, these schemes, the confirmation of service demand, the production orders, to be used with cooperative third parties that police have long-standing relationships with. If a service provider is not cooperative, police have other tools that they can get. They could get a production order that compels, or they can get a warrant that authorizes them to do the work themselves. So there are other means of doing this. Again, this is a tool to be used with cooperative third parties. It provides those third parties with a piece of paper that indemnifies them because they're responding to a state request. So it satisfies their need and hopefully satisfies the police needs as well.
I have doubts, about the effectiveness of the legislation if that's so written. And, okay, two more questions. One is, now, in the case of a company who might be operating internationally, and if there's a conflict within the jurisdictions between countries, if the company is being bound by another jurisdiction not to release that kind of information, what will happen?
Thank you again for the question. It's the same response as when they have a conflict of laws for contractual reasons. If they have a jurisdictional conflict of laws, they could also object because they're not allowed to release the information for those purposes. So it's the same process. The clock would stop. A judge would hear whether or not the objection was reasonable and the conflict of laws was reasonable as well.
Okay. The last question, which I raised also last time, saying that there's also a temptation, when you're given the power, you have the tendency to use it more and more, So, what are the measures in the legislation or through other channels that would forbid the law enforcers to overuse or to abuse that kind of authority?
Thank you again for the question. The confirmation of service demand, I'm not sure the exact figures. There is a large segment of the telecom sector that provides this information without any piece of paper because they don't see it as being privacy invasive and they want to give assistance to police. That portion of the industry that requires a piece of paper, instead of a production order, and again, the only one available for this type of information currently is a general production order, which is quite difficult to obtain. They would be subject to this new confirmation of service demand. So it's a new tool. We don't know how often it's going to be used, and I think there are other motions later on that are asking for some sort of review. So if those pass, the proof will be in the pudding, so to say.
Well, thank you. Actually, you remind me of another question. So are you saying that you have no estimate how many times this piece of legislative power will be used? You have no idea how many times in the future that this authority will be used?
Sorry, I don't, but perhaps the law enforcement officials here might have some idea.
Anybody can answer the question?
Thank you for the question. It's pretty hard to look into the future to see how much it would be used, but this investigative technique is already used in every investigation across the country as we speak. The added piece to this particular confirmation of service demand that's different is that it documents our request, and that goes on the investigative file, which is disclosed in court. So there'll be more scrutiny to these requests than there currently are.
But again, based on your experience in law enforcement, so I mean, based on previous experience, so what would be your estimate? Can you say that, okay, from my experience, probably I can say that 5 times, perhaps, in the past, I could have applied these new measures in order to facilitate my investigation. So, I mean, just give me some general idea. It's good enough. I'm not asking for statistics per se.
I think it would be problematic to try to make a guess like that. I couldn't even come to a number for you that would be in the realm of, reality at this point. That's trying to look into the future to say how often we would do a confirmation of service demand and document that for the file. I wouldn't be able to respond to that for you today.
It's also hard for them to answer for all of different police and jurisdiction across the country because they wouldn't necessarily have line of sight on that.
Yes. See that I understand. Thank you.
To step in?
I was just going to add a little point there, but my hand up to my colleagues didn't really work there. Maybe to give you, MPL, a little bit of color from our perspective. Excuse me, the intent is to continue to try to go voluntarily in this space, and especially after the 2014 Spencer decision that we talked about, I can speak for us in saying that the sort of stickiness, so to speak, to use Rick's example, those that need a piece of paper, maybe it was norms, has largely been in the telecom sphere. And so what this does for us is this gives us a backstop that if we can't get it voluntarily, we do have the authority. So really, it's hard to say the number because what it would depend on is whether that stickiness persists or whether actually because it's legislated, we get less of that, really. So it is the response that I think would dictate that. Thanks.
Thank you. MP Caputo is next. Just no pressure, MP Caputo, but when you're over, we'll stop and suspend for a few minutes for dinner.
I was actually going to suggest that we suspend now. Not yet. It's not yet ready? Oh, okay. Well, no pressure then at all. May I ask, Mr. Chair, before we're going, do we have a cutoff time at 7:30?
Well, I'll check with the clerk whether we have resources after 7:30.
Because it would be helpful if we knew. I know the meeting started late. I think it would be helpful for all of us. I mean, hey, I don't mind working, but I think it would be helpful for all of us to know when the meeting is expected to end.
Good.
Okay. All right. I'm going to come back to what I was saying earlier because I pulled out the provision when I was speaking with Mr. Wong. The point I was trying to make is right now in sub 2 it says the peace officer or public officer may make the demand only if they have reasonable grounds to suspect that an offense has been or will be committed under any act of Parliament. Now, that change under Ms. Kwan's NDP2 amendment is to change it to reasonable grounds to believe. If we look at the criminal code under section 495, this is the point I was trying to make. Sorry, I'm just off of the section here. It says a peace officer may arrest without warrant a person who has committed an indictable offense who, on reasonable grounds, he believes has committed or is about to commit an offense. So there's the parallel I'm trying to draw, is in 495, it talks about arresting on reasonable grounds to believe. Ms. Kwan's amendment talks about making a demand on reasonable grounds to believe. I hope that the parallels there are fairly clear. The reason I'm drawing that parallel is because reasonable grounds to believe in the case law has been defined, for arrest anyways, has been defined as below a prima facie case. And for those, now my recollection, again, it's been a few years, but my recollection is a prima facie case is actually a fairly low threshold in law. So, and certainly below a 50% threshold. The point I'm trying to get to is is given all of that, is the reasonable grounds to believe threshold all that high? I get that it's higher than a reasonable grounds to suspect, but if in the context of arrest, it's below a prima facie case, could it be said that in this context, given Ms. Kwan's amendment, it's actually not that high of a threshold? Am I making any sense here?
Mr. Caputo, if I could answer the question, you're making complete sense. And so what I would say is that that the standard to ask somebody if Kim Gibner, if you provide services to Kim Gibner, yes or no, I would say that should be a different standard than somebody who's being arrested.
No, and I understand that that's different, but if we adopt Ms. Kwan's amendment, the threshold, say under 495, is reasonable grounds to believe. The thresholds under 487.0121 would also be reasonable grounds to believe. Do you get what I'm saying here?
Reasonable grounds to believe is reasonable grounds to believe everywhere in the criminal code, if that's what you're...
So that's, okay, therein is my point. Reasonable grounds to believe in the context of Section 495 is below a prima facie case. Now, that's a fairly low threshold. In my view, it's above a hunch and above reasonable grounds to suspect. But if we're articulating it as below a prima facie case under Section 495, would it not be below a prima facie case under Section 487.0121? That's what I hope I'm not getting too technical, but that's my point, is I'm trying to deduce exactly what that threshold of reasonable grounds to believe actually means.
I don't know what he's referring to when he's talking about 1, 2.
Am I making any sense?
Mr. Caputo, I apologize. I don't understand your question. So is reasonable grounds to believe a high the threshold? It is the criminal code threshold used for many things, as you pointed out, to arrest someone and to search your house. And the standard has been described in many different ways, and we can go over some of the language that describes what reasonable probable grounds is. And so reasonable grounds to suspect is also a standard, which is also above a hunch, also discernible facts that an officer would have to set out. The reasonable grounds to suspect, it is a standard that has been approved by the Supreme Court of Canada. It is in the criminal code. And so for the confirmation of service demand, is Kim Gibner, you do provide services to Kim Gibner, yes or no? The reasonable probable grounds was determined to be too high. It's not the same thing as searching your home. It is a less intrusive information, and so the reasonable grounds to suspect was put before you in terms of being the right standard.
Okay, and so perhaps I'm not articulating myself here correctly, Ms. Gibner, because what I'm getting at is what is in Ms. Kwan's amendment. That is, we are dealing with Ms. Kwan's amendment was moved, and that is NDP 2. Are we not on NDP 2 right now? Okay, so that's where I think we're getting our wires crossed here. I worry because Ms. Kwan's amendment, I've got it right here, demand only if they have reasonable grounds to believe. So the analogy I am trying to draw, the parallel I am drawing, and is reasonable grounds to believe is used throughout the code. If we accept this amendment, reasonable grounds to believe will be in the subscriber demand section. Reasonable grounds to believe under the arrest provision has been interpreted to be below a prima facie case. Are you with me so far here?
Yes.
Okay, so if reasonable grounds to believe has been articulated as below a prima facie case when it comes to arrest, would it not be similarly interpreted to be below a prima facie case on reasonable grounds to believe when it comes to Ms. Kwan's amendment? Do you get what I'm saying?
Yes.
Is there an analogy to be drawn in the interpretation?
maybe Mr. Wong will, I'm not answering your question. I'm not being of assistance to you, so maybe Mr. Wong will take a run at that.
Thank you. I think I understand your question now. The contexts are completely different. One deals with Section 8 of the Charter, invasions of privacy and whether or not they're reasonable. The standard there that is used is reasonable grounds to believe or reasonable grounds to suspect. When you're talking about 495, and forgive me, I'm not an expert in arrest powers, but to me, it's not about Section 8, it's about Section 7 and other issues. So it's about your freedom, it's about public safety and risk. So there are other sort of factors to consider in those cases, and prima facie is not a standard that we use in terms of investigative tools. So maybe that's why we were a little confused in terms of that. So the reasonable grounds to believe, I think, in 495 would have to be read with the law around habeas corpus in Section 7 and not with respect to Section 8 and invasions of privacy.
Okay, that's a fair comment. You're right. Section 495 engages Section 9, which is the right to be free from arbitrary detention. The reason I'm going there is because what I'm trying to determine is what this threshold actually means. What does reasonable grounds to suspect mean versus reasonable grounds to believe? That's what I'm getting at. And in the arrest context, it is a personal subjective belief that is below a prima facie case that is objectively reasonable. That's my reading of Supreme Court of Canada. So, like, where does that leave us then? What is reasonable grounds to believe in this context, in your view, versus reasonable grounds to suspect?
Thank you again for the question. This isn't necessarily my view, but there's lots of legal literature out here on this, and I believe in earlier hearings, I think when we appeared here for when the bill was introduced, you mentioned that it's below a balance of probabilities, reasonable grounds to believe. And there are a lot of legal scholars that talk about that threshold. So the top of the pyramid would be beyond a reasonable doubt. The civil standard balance of probabilities is somewhere in the middle. And the highest standard in the criminal code for investigative purposes is reasonable grounds to believe. So it's somewhere below balance of probabilities, but it's above reasonable suspicion. So in 93,
okay. I see.
The Supreme, sorry.
That's helpful because I took earlier comments to state that reasonable grounds to believe was above a balance of probabilities. And I think that's very important. I know that this sounds very nuanced and we're just hammering at something. The degree to which somebody must believe is very important for the purposes of this amendment. It really is, because we're talking about whether, yeah, I think an offense might have happened, I suspect it, versus I believe it is. If it goes reasonable grounds, if it goes hunch, reasonable grounds to suspect, reasonable grounds to believe, balance of probabilities, to me, that's a very important point. And I guess when I consider that, especially when I consider the higher threshold and the issue that was brought up by Professors Geist and Diab, for instance, saying, oh, I don't know, like I'm worried about Section 8 being engaged here, especially if you're looking at a Section 1 analysis and thinking, have we crafted this as narrowly as possible on the proportionality test? I'm not as uncomfortable with the reasonable grounds to believe threshold because it's not that much higher above a reasonable grounds to suspect. Higher, but still below a balance of probabilities. So to me, that's very important. Sorry, do either of you want to comment? Feel free. I hope I'm not talking you into circles or talking myself into circles here. Is dinner ready yet? No, it's not ready yet. Oh, it is.
When you're ready, we are ready.
Oh, I'm ready. Let's go.
Yes.
Yeah.
Ready?
Let's pause there.
Okay, so we'll suspend for 5 minutes. Merci.
I'm very charming.
On va prendre 5 minutes.
We will resume in 5 minutes. Good evening and welcome back to our sitting. We are now going to continue. MP Caputo had the floor. The floor is yours.
So, very interesting stuff. I find this stuff absolutely fascinating. One thing that was raised with me in the break is that, in fairness to the officials, I am asking, these are not easy questions, okay? I'm not pretending they are easy. That's why I'm asking them, because they are tough. But when we're establishing the threshold of grounds to believe, something that you suspect versus something that is probable was raised in the break. As in, it's more probable than not in your eyes that this happened, or you believe that this happened as opposed to you think this could have happened, which I think is above that 50% when it's framed that way. And I guess one of the questions is, and this was raised to me in the break that I hadn't considered, is this analysis of reasonable grounds to suspect versus reasonable grounds to believe, is it animated or informed by the stage at which you are in, that you, being a peace officer, law enforcement, is at in their investigation? In other words, the service demand threshold, it happens right at the outset. Does that impact, how does that impact grounds to believe versus grounds to suspect? Does that make sense? Does that have any impact on it in that it's at the outset of the investigation?
Absolutely, Mr. Chair, MP Caputo. Thank you very much for the question. That's absolutely, you've hit the nail on the head, right? So we've talked about calibration between privacy interests and law enforcement. The nature of the tool, when the tool is going to be used. That's absolutely when both of these tools, the confirmation of service especially, it is absolutely at the very beginning of the investigation where they have very little information. They can get over the reasonable grounds to suspect. They have enough information to get there. But what you've heard them say is right now they're using a general production order to get that kind of information and the subscriber information, and the reasonable probable grounds is just too hard to meet at the very beginning of an investigation. And I think it might be, as you're deliberating, I was looking at the March 10th, 2026 Jurastat, the statistics on crime. And so in the report, it notes that in 2024, 16,905 incidents of online child sexual exploitation were reported by police. That was 110% higher than in 2018. And that of those cases, 94% of those online child sexual exploitation cases were not cleared by police, meaning that accused had not been identified in connection to the incidents, or there was insufficient evidence to get a tool. So that's exactly what you've highlighted, MP Caputo, is that this sort of what we've been calling sort of one of the most least intrusive tools out there is calibrated for the very beginning of an investigation.
Did you see a scenario, hypothetically, in which the committee may say, okay, this is a lower threshold. The committee may, I'm just speaking hypothetically here. I'm not just signaling which way I would vote on an amendment. But could it be that, okay, simply identifying who a subscriber is much lower, a much lower threshold of intrusion, as you would put it, and that's why you could justify a reasonable grounds to suspect, as in a crime has possibly been committed, and we just want to know whether this person is a subscriber. But then once you get to an authorization to get more data about them, and that is in the production order, which is judicially authorized, could you not then say, okay, well, now you're getting a lot more information, therefore it could be justified that that goes to a higher threshold?
Thank you for the follow-up question, MP Caputo. I think what I said stands for the subscriber information as well. Again, it's really, we know who, which service provider provides the service. So now I can go to court and ask a judge or a JP to authorize the warrant, and I'm going to set out the grounds that I have to get very minimal information, name, address, to conduct at the very start of an investigation. I'm going to be able to collect some basic information. So I think what I said, or at least I'm trying to be helpful to you, that's how I would think through that problem.
Fair enough. I mean, I'm trying to work this through, and I get your one step. Once you've got the information, or the subscriber demand, and then you've got that subscriber information, you're only theoretically one step further ahead once you go to get that authorization for the subscriber information, is, I think, if I'm taking your point correctly. So we're actually not that much further ahead in terms of determining, well, now are there reasonable grounds to believe versus reasonable grounds to suspect. Now, if you could settle a bit of a debate between my colleague and I won't say who's on what side, but let's say Section 487.0121 offends, sorry, that's the section we're looking at. Let's say a court says, you know what, this offends Section 8 of the Charter. This legislation, not the way it was carried out, but the legislation itself offends Section 8. Would there then be a Section 1 analysis as to whether or not that is a reasonable limitation on the Section 8 Charter right to be free from unreasonable search and seizure? In other words, do you perform the Oakes test on the legislation if it's found to infringe Section 8?
Thanks for the question. I think we've stated this before. Every piece of legislation that is introduced by the Minister of Justice has to be charter compliant. That's part of his mandate. We are not the charter experts where we work. There is a unit at the Department of Justice that examines all legislation and would do the analysis that's required to make sure it's charter compliant.
No, I understand that. We were just debating about whether Section 1 would apply, as in could it be saved by Section 1, but it sounds like that's not your area. Okay, fair enough. I'll give the floor to MP Mantle here.
Thank you.
Before I finish, do we know what time we're finishing up here, please, Mr. Chair?
We have resources until between 8:10 and 8:25.
Okay, thank you.
MP Mantle and then MP Kirkland.
Thank you, Mr. Chair. This is the big issue in Part 1, in my view, so I'm going to spend a bit of time on this. The threshold is a key part to both the demand for or confirmation of service demand and then the production order. Before I do that, I just want to reiterate that I think should we be able to deal with this particular issue, which is the standard to apply in Part 1, that would take a lot of I don't know how to describe it. That would take a lot of the problems that we see off the table with respect to Part 1, which to what we have offered already, and we will continue to offer the government here, is to work with us on this type of amendment to Part 1. And if we can deal with this type of amendment for Part 1, I think we can get to a place where then we could start discussing again Part 2, which I think everybody reasonably understands is the more contentious part. So in the hope that that will happen, I'd like to seek unanimous consent for the following, Mr. Chair.
First, you want to table to move a motion?
No, I just.
You want to move a motion, or?
I'm not moving a motion. I'm just asking for unanimous consent right now. It would be as follows: that Windscribe be invited to provide testimony in relation.
I'm sorry to interrupt. That's a motion. So you need to have unanimous consent to move a motion, and then if you have unanimous consent, you can then present your motion. So is there unanimous consent to presenting a motion?
Okay, then, Mr. Chair, I'd like to put a motion on notice orally. Okay. Here's the notice. that Winscribe be invited to provide testimony in relation to Part 2 of Bill C-22, an act respecting lawful access. I'd like to put that on notice. I don't have that translated, but we can provide that in due course as we're just putting it on notice. I would like to return. I don't believe, Mr. Chair, I need unanimous consent to ask for, just to see if the committee will unanimously consent to inviting somebody to provide testimony. That's not a motion. I'm not making a motion. I'm just asking for unanimous consent.
Well, you cannot ask unanimous consent for something that you're freely able to suggest. If you want to have a motion tabled and then moved, then you need to have unanimous consent.
I've put it on notice, and that's fine. And when that comes up, we can debate that. But the committee is master of its own procedure. So I would seek unanimous consent to invite Windscreen to attend.
I'm sorry. So yes, you can express these views. You can have a notice of motion. That's all right. But then we cannot have a motion moved if you don't have unanimous consent.
It's not a motion.
So
I'm seeking unanimous consent from the committee to take an action.
Well, that's a motion. So you would like the committee to do something. That's a motion. You need to have unanimous consent before you introduce a motion. Or you can express a view, a general view, or you can have a notice of motion.
Completely not correct, but the committee can do whatever it likes in terms of its process if it decides to do so by unanimous consent.
No. The way the committee works, and we don't need to, and we don't want to, we have other things to do. The way the committee works, it was first to agree on a set of procedures. If we want not to follow those procedures, we need to have unanimous consent. So if you want to table and move a motion now, when we are in the process of studying a motion, you need to have unanimous consent then to be able to move a motion.
We went, I mean, you're the chair, you'll make your decision, but I would just say for the record, we went through the routine motions last time. There's no routine motion that defines exactly what you've just said, which that there's a set of process for this meeting. It's open to the committee to govern its own proceeding, including by unanimous consent.
Well, you can seek unanimous consent, but you've already done that a moment ago, and you didn't receive unanimous consent.
Okay, great. So as long as that's clear, because my understanding is it's not your role, Chair, and respectfully, to deny unanimous consent. It's my ability as a member to ask if there is, and it's your role to canvass the members of the committee to see whether there is unanimous consent.
This is entirely right. It's not my role to deny unanimous consent. It's my role to seek it, and it wasn't obviously there.
Great. Then I...
Oui, Madame
Appel au règlement, excusez-moi, Monsieur Mantel.
A point of order. Excuse me, Mr. Mantle. So I've understood we're going to be here until 8:30. Perhaps we could invite the witnesses to serve themselves. I hope that they have done so. And if that's not the case, then Ms. de Bellefeuille, you're very charming. That would be very humane because we have served ourselves. And this is a committee of equity and equality. And so I hope there is food left for the witnesses. And if so, you can certainly serve yourselves. Mr. Mantle.
Should we move to MP Kirkland?
No, I'd like to continue, Mr. Chair, on this discussion of the standard to apply. So I want to start with our law enforcement colleagues. I want to understand your view of the process right now through the general production order. Can you walk me through that process today?
Thank you for your question, Mr. Chair. I suppose the way we would walk through a general production order is that we have to meet certain grounds or certain obligations before we can actually present it to a justice who's going to decide. So one of the main obligations that we have to establish is that the evidence likely exists, but in the possession of the person or the entity who we're actually addressing the order to produce to. So essentially, our initial, at the outset, we're trying to establish who might actually be in possession of the information. So we do essentially ask questions to who might be a provider in hopes that they will respond in the affirmative that they were providing services at a certain date at a certain time. If that fails, then that can end at least that point of an investigation. So I would say to start off an investigation, that could hamper or completely stop the progress if we're unable to confirm right away that this entity does hold the evidence that we're actually looking for.
Apologies. That's just for the confirmation of service, subscriber information, right, that you're talking about there?
No, sorry. I thought you were asking me about our current process.
I've confused in my mind.
Okay, sorry. I'm referring to our current process. Our current process, we do have to establish that the evidence is likely in the possession of the person who we're actually addressing it to. So we do typically start off by asking questions, which is why confirmation of service is more of a codification of our existing practices. But as my colleagues had mentioned before, not all service providers actually respond to this.
My understanding is that you do that now. You ask whether it's a ISP or a tech company or some other entity if they're providing this service, and many of them respond to those presently. I'm thinking of the companies that produce transparency reports, for example. So they will at whatever level they are requested information from law enforcement. If they do that, then they produce a report, and it's online. You can see it. So, for example, Googles and Apples of the world produce these. So that's the kind of back and forth that's the initial step for you.
Well, depending on the investigation, that can start off our investigation. Where we do run into some issues is in establishing who actually might be in possession, and it might be a chain of providers that might have that information. And so what can hamper an investigation as well would be, for example, you have a reseller of IP services. And so this larger provider sells its services to another provider, which resells its services to a web hoster, for example. But according to the information that you have, it belongs to the larger provider. But if you write a production order to that larger provider, by the time you receive a response, they might be saying that, oh, in this case, it actually is the smaller provider that has the information that you're looking for, which would lead to another production order and so forth and so on.
That's like Rogers resells access to like a more local provider, and they provide in a local area. So it's when you ask Rogers, they're just saying, well, it's not us. It is them, but they sell that, wholesale that on. Okay.
Be in possession of the actual subscriber information, but they would be in control of the IP range.
Okay.
Oh, sorry.
So keep going. Yeah.
Yeah. So then once we have established who would actually be in possession of the subscriber information, then we write our production order or our information to obtain a production order, which would lay out the grounds that allowed us to believe that an offense has been committed, and this information will actually provide evidence to that particular offense. Now, that grounds to believe would be based on our perceptions also, because, for example, if you receive information, for example, internet logs, they might not be, you might not look at them the same way as I would, for example, based on our previous experience, based on what we know about internet logs. And then we have to show how we actually attempted to corroborate the information that we've received and spell it out in a way that would make potentially anyone, or in this case the justice or judge, based on their criteria, also believe that there has been an offense that was committed and that this information will provide evidence of the offense.
Okay, and I think you sort of embedded the discussion of the standard in your response, but maybe you could just hone in for me where the current standard sort of comes into play for you when you start thinking. I mean, it's obviously throughout. I assume you're understanding the test you need to meet to get the production order, but maybe you could just hone in, because you didn't say like, okay, now we're thinking about what the standard is and what we need to meet that. Maybe you could just hone in for me on that, because I want to contrast it to what's being proposed. That's why I'm asking.
Okay, I suppose if I would give an example, it would be Bob says that he's receiving calls in the middle of the night. They're harassing calls, and that they are from Alice. So now he is able to show me a phone number which he received the calls from. So now I have no confirmation quite yet that there's actually a crime that's been committed, because I haven't heard the calls that have actually gone through. But I do have a phone number, and so I suspect that there may have been an offense that's been committed. So I can reach out to a service provider and ask, do you provide services to this particular phone number? If they respond yes, well, okay, now I can move on to, in this case, it would be subscriber information production order, because I'm still not quite sure yet that there's an offense that has been committed, or it's not probable. It's possible, but it's not probable yet. So if I receive a response that confirms that this account belongs to Alice, well, now I start to increase my grounds, because now Bob says that Alice was the one who did it, and this account happens to come back to Alice. So I'd have to do some additional corroboration, but we're on our way to building grounds to believe. So it's a step-by-step process.
Okay, and with the change that's proposed, how does that change that process for you?
Well, that would actually facilitate our process greatly. So in terms of confirmation of service, if we can ask the providers if they do provide services. So you have, for example, like I mentioned before with resellers, if I can confirm who actually provides services right away, just through a confirmation of service demand, which can be sent out to who the service provider who possibly would have this information. If they confirm that, then I can move on to the next step at the same threshold, or at a reasonable threshold of grounds to suspect, and I can immediately write a subscriber information production order. Receiving that response that much faster, I can then move on to with my investigation. So it's not only that it's going to confirm what I think, but it could be exculpatory as well in eliminating the possibilities that this was an individual who did commit the offense. So I could either end the investigation more quickly, or I can move on and carry on my investigation more quickly.
Okay, that makes sense. I don't know if there's any, Cesar, is your process the same or different, or anything you want to add on that? I don't want to.
Nothing to add on that.
Okay. Public safety, you're good? Okay. Because in the example that you've provided, I think this is again why this raises the standard issue. Because in the example you've provided, I guess I'm only speaking for myself at this point. Like, that seems to make some sense in for the phone number and going from there. The problem I see is that, especially with paragraph C of the definition of subscriber information, it's contemplating a whole lot more stuff, including, I think, information that would go to that biographical core that the Supreme Court has said. So that's why I thought that clarifying the definition was important. We didn't do that. Okay, fine. But now we're on the standard, so I want to get the standard correct, because if we're going to touch things like, more expansive than just your telephone number, whose telephone number it is, both on the first confirmation of, do you provide service to this telephone number, and then the production order, both of which have the same standard. The same will both have the same suspicion standard, right, Ms. Gibner? I've got that right? Okay, thank you. Then, in that case, I am a lot more concerned about having the higher threshold of grounds to believe in that case. Okay. What I want to know, and maybe this is more a policy question for public safety. I think, thank you, Mr. Gilk, for outlining that your process. That's helpful because I wanted to compare, for my benefit, current versus how you see proposed. But maybe I could put the question just plainly to public safety. Why did you choose to select a lower standard? Because that was a conscious choice. Is that correct? Conscious? I mean, it's in the black and white.
Yes.
I assume it's a choice.
It is a conscious choice. It would be more a question for my colleagues from Justice, but
Sorry,
yes.
yeah.
But it was a conscious choice to.
Yeah. Which is again different from previous proposals for lawful access, including Bill C-13 in the past. That did not have the suspicion standard. It had the grounds to believe standard. So, am I incorrect there? Okay. My apologies.
The Spencer decision came out in the middle of 2014 when the other. So
okay.
That's why I think there's a different context today than there was in 2014.
Right. Okay. And your point there also raises another point that I wanted to make in response to something Mr. Wong said, which is he made reference to like the issue in Canada is that we don't have the same process as other countries. But in fairness, I think you've omitted to mention the reason we have that difference, which is the Constitution and the Charter and the way that has been interpreted to establish the jurisprudence around privacy in Section 8. So I think that's important context because I've heard again and again and again, Five Eyes, G7, G20, Australia doesn't have a charter, right? They don't have the same history of that protection of privacy that we do. And that's a fundamental difference. Now, I would argue common law would give you some of that too, but they haven't gone down that path. So I just want to make the point that I don't think it's apples to apples, a fair comparison that I've heard made, and I'm not suggesting I've heard all of you make that, but just to perhaps finish Mr. Wong's thought, the issue in Canada, there is a difference, and it's because we have the Constitution. Wanted to make that point. So, Ms. Gibner, back to my question is conscious choice. Why go for a lower standard?
I'm going to start the answer, and then I'm going to pass it to my colleague, Mr. Wong, because I think he answered your question about 2011. There was actually an administrative, so they set up something more akin to the international community where it was done administratively. It didn't require a warrant with the judiciary, and so that might be important for you. So I'll let him speak to that because I, unlike Mr. Wong, was not here in 2011 or 2013. But just to start the answer, I just want to again step back and sort of remind ourselves and the committee that is exactly what policy development is in the criminal law space. It is thinking about, Section 8, because as you pointed out, we have a charter. We have to be charter compliant when we're thinking about balancing privacy rights and the needs of law enforcement. So yeah, it was a policy choice based on what we've talked about tonight, which is, what is law enforcement seeking? What is the goal and objective of the tool? What are they trying to achieve? And it has to be calibrated, as we talked about earlier, about like when the tool would be used. So all of those different factors, the type of information being sought, when the tool would be used, the nature of the privacy that's being intruded upon, and so that's how we came up with that standard. Again, if it assists you at all, I always like to compare. So when you're looking at the financial data and it's grounds to suspect, it's like, okay, well, this is a little bit less than that, or the search warrant to search your home. Well, that's reasonable probable grounds. We're not going in anybody's house. We're just asking if, Kim Gibner is a client of yours, yes or no. So it's those sorts of considerations that we came up with this policy. Mr. Wong?
Thank you, Kim. I would just add that when we're developing the policy on this, just to underline something that Ms. Gibner said, is that these tools exist on a privacy spectrum, and we try to not reinvent the wheel. We try to compare apples with apples and not oranges, and this tool is very similar to tools that already exist in the criminal code. And what the objective of this bill is trying to do is to provide police with tools that will provide them with timely access to data. They already have a tool, the general production order, that they're using under reasonable grounds to believe. So if this were raised to the level of reasonable grounds to believe, you'd be, in my opinion, you'd be undermining the objective of the bill.
Thank you for that. Again, I want to push back a little bit, Ms. Gibner. I think, as I've suggested tonight, and I will continue to repeat, I think the subscriber information that could be required, either for the confirmation of service or in the production order, especially in subsection 3 or subsection C, sorry. Could go far beyond simply, do you provide information to Ms. Gibner? And so the privacy interest that attracts, in my view, is higher, which leads me to my belief. Sorry, it sounded like you wanted to jump in.
No, I just want to make sure that we're talking about the same thing. So confirmation of service demand is without a judicial warrant, reasonable grounds to suspect, and that is Kim Gibner your client? So just to be clear, that's that one. That's all I meant about that one. And then I totally take your point that within subscriber information, you've identified that C could possibly raise different considerations, and so that will be for the committee to decide. I think I was trying to be helpful to you to explain that we looked at the tool more broadly in terms of setting out something that was about basic subscriber information. I take your point that you're looking at C saying, well, what about? And
just for the record, I find everything you're saying very helpful. It's not my area of practice, and as you often say, you know just enough to be dangerous. So I'm trying not to get myself into any danger here. But we've been talking a lot about the confirmation of service, and especially ISPs. So I would like to ask the chair to canvass the committee for unanimous consent to invite DuckDuckGo, a provider, to be invited to provide testimony in relation to Part 2 of Bill C-22, an act respecting lawful access.
Is there unanimous consent for that? No.
I'm seeing that there's was no unanimous consent, so therefore I would like to orally put that on notice as well.
Okay, thank you. Well noted.
Is
Should we move on to MP Kirkland?
No, I'm not finished.
No? Okay.
Yeah. I'm not finished. Okay.
I'm kidding.
So, to go back to, we were talking about the two decisions earlier, Ms. Gibner, the Spencer decision, and I don't think we talked about Bajkovic, but Bajkovic is the second important one. And this goes to my question about which type of information is attracting which degree of privacy. And granted, maybe there's a bit of overlap here between the confirmation of service and then the subscriber information. So bear with me there. So my understanding, though, is that Spencer, the Supreme Court said that subscriber information attracts a high degree of privacy because it connects a person's identity to their online activity. Is that a fair ratio for the judgment? At least one part of it.
If I may, our interpretation is that the Supreme Court said there's a high degree of privacy when you connect your identification with your online activity. So it's the combination of the both, not subscriber information on its own.
That's fair, but these two things are connected, right? Because you confirm the service at the suspicion standard, then you use that information that you got, no judicial authorization, then you go get judicial authorization for the production order, in part based on that confirmation of service, right? Because now I know the information, I know that Kim Gibner is being provided service, so now I can go and say, okay, on suspicion standard, I think the evidence that I need for this suspected crime is on Kim Gibner's phone.
I just want to add one thing, which is just to remind ourselves, though, that we're at the start of an investigation. When we heard the officer say, I can't start my investigation because the production order requires me to know who the service provider is and that it'll afford evidence of an offense. The confirmation of service demand does not have that criteria. It simply says that it will that offense has likely been committed, and that the information I get will assist my investigation. So it's just the tool is meant to be at the very beginning of an investigation where all they want to do is to know where to start. So I just, something you said, thought that might be helpful for you to know, and then I think you wanted to address his point.
If I may, Mr. Chair, I just wanted to add that the facts in Spencer were very specific as well. It was not only the identity to the online activity, but Mr. Spencer had been on a file-sharing platform, LimeWire, and police had been observing him for some time. So they had a body of evidence about the activities of this IP address that was publicly broadcast and was downloading known files of child pornography. So that it's a very different context than subscriber information in isolation, or even connected to a sole IP address that might be linked to an email address that sends harassing email messages. So it's very specific.
That's fair, thank you. But the second decision then extended that reasoning to the IP address, right? And you said the start of your investigation, and in that case, the Supreme Court used the word first digital breadcrumb, I think was one of the words they used. So, like, I get what you're saying, it's the start of the investigation, but also the IP address, which we've been discussing as sort of basic information or not, is the first digital breadcrumb that you get to confirm that the IP address is Kim Gibner's IP address. Sorry to keep picking on you. I'll pick on someone else. I started it. Yeah, it works. So the point I want to make here, and it goes to the earlier question I asked you, Mr. Wong, about other places in the criminal code that use the suspicion standard. And I would like you or Ms. Gibner to make the argument for me that that transmission data, tracking data, financial data, those are the three I was able to take down in time that you said, the three of the four that are on the suspicion standard. Make the argument for me that is an apples to apples comparison to the information that you're on the confirmation of service. Because you're saying, I don't want to put words in your mouth. What I'm understanding is one of the arguments is, okay, well, in other places in the code, there's this lower standard, suspicion. One of those places, let's take transmission data as the example. Transmission data, similar to basic confirmation under the first step of our investigation. So is that the position? And if so, persuade me that that's apples to apples.
Thanks for the question. I would not quite say it's apples to apples, because if it were apples to apples, it would all be under a production order, because the ones under a production order, we do think that there is a reasonable expectation of privacy. It's not as high as reasonable grounds to believe, but at the lower threshold. You brought up Bajkovic. What happened in Bajkovic, the unfortunate facts were that police obtained the transmission data without availing themselves of a production order. And that's where the investigation sort of went awry, and we ended up with the Bajkovic decision. So I don't think Bajkovic would have happened had police actually used the tools that were in the criminal code and available to them. In the confirmation of service demand, we have to give the police some threshold in terms of doing their police business. In terms of privacy expectations, the things that are on the lowest end of the privacy spectrum, we attribute the reasonable suspicion standard when we have to attribute a standard. In terms of the confirmation of service demand, the police have done certain amounts of work, so they might come into possession of an IP address through an investigation of a complaint, like I said, a harassing email. Behind that email address, there's an IP address through which it was sent. So they've obtained this information in a legal manner. All they need to do is connect the dots, and the first step in that is that they have to find out which service provider actually provides service to this IP address, because without that, they won't be able to serve the production order for subscriber information. So they're not apples to apples in that respect. The reason it's a demand is because really there's no core biographical information, as you mentioned, in which service provider your phone number is served by. But that is the first sort of indication for police to be able to get the production order, where they can get that first bit of real evidence towards investigating the crime.
Thank you. I think you've made the point for me that I am concerned about, which is they're not the same, and that's why they should have different standards in my view. I think transmission data, based on my review, is the technical details of a communication being sent. It's not an identifying piece of information, and so the argument there is then that you can use suspicion. But, and I take the point that we're at the first part, we're not at the production order part, but we will get to production order part, which I also think should be raised to reasonable to belief rather than suspicion. But even at the beginning, it's still something different than just a technical data of a point of communication going from A to B. It is saying Kim Gimner is connected to this IP address. So I think based on my read of those two cases, the suggestion is that even that can attract the higher expectation of privacy.
If I may, Chair. I'm not sure I understood you, but the confirmation of service demand does not connect Kim to the IP address. It connects Rogers to the address so that they can find out that it's Kim.
Yeah.
So it's one step to remove.
You're right. My apologies. You are right. It's sort of one step before what I suggested. Okay. Did it in maybe I'm just deciding if another point I want to raise is perhaps better in the discussion of the production order itself, but yeah, maybe I'll save that. But I do want to raise sort of my view on just the idea of the standard within why the reasonable sorry, I'm getting the standards confused. Belief. I'm going to say belief versus suspicion just for shorthand. Why the belief suspicion is important under Section 8. Because my understanding is belief means you've got to have not belief. That standard means you got to not just think that there's been a crime committed here, but there's evidence, there's objective evidence that's going to be in the place that I want to look, and you have to have an objective basis to say that as well. And I think that's important. And I want to go back to actually sort of the genesis of this, which again, I was like with Ms. Sullivan here, I had to go back to some basics, which is, which if I can find my note here, as I understand is the Hunter and Sullivan case? Southam, thank you. Sorry, I didn't have my note. I was trying to go from memory here. But I have it here. Yes. Hunter and Southam. So to me, this is like the starting point and why I also think that the standard should be higher, because this encapsulates, and I'm not going to read the whole case because, again, but there are two key paragraphs I want to put in the record for my view on the importance of the higher standard, whether for the first step or whether for the second step. And just by way of background, if you'll remember, that case was the anti-combines, as it was called, organization, which is an olden time word for like antitrust competition organization, investigating a newspaper, actually. And the general details, as I recall them from my notes here, that they could sort of give themselves their own power to enter into and get information. And in reviewing whether that warrant to go into Southam's office was an unreasonable search and seizure under Section 8, which had just come in. It's like the first case, I guess, or one of the first cases. The court did take some time to sort of explain that objective portion of Section 8. So I just want to put on record the two important paragraphs for me in talking about that objective criterion. So the court said, the purpose of an objective criterion for granting prior authorization to conduct a search or seizure is to provide a consistent standard for identifying the point at which the interests of the state in such intrusions come to prevail over the interests of the individual in resisting them. To associate it with the applicant's reasonable belief that relevant evidence may be uncovered by the search would be to define the proper standard as the possibility of finding evidence. This is a very low standard, which would validate intrusion on the basis of suspicion and authorize fishing expeditions of considerable latitude. It would tip the balance strongly in favor of the state and limit the right of the individual to resist to only the most egregious intrusions. I do not believe this is the proper standard for securing the right to be free from unreasonable search and seizure. In the last paragraph here, Anglo-Canadian legal and political traditions point to a higher standard. The common law required evidence on oath, which gave strong, quote, strong reasons to believe. And that's a reference to Entick and Carrington based on entering into somebody's property. Strong reason to believe that stolen goods were concealed in the place to be searched before a warrant would issue. Section 443 of the code at that time authorized a warrant only where there had been information upon oath that there is, quote, reasonable grounds to believe that there is evidence of an offense in the place to be searched. The American Bill of Rights provides that, quote, no warrant shall be issued but upon probable cause supported by oath or affirmation. The phrasing is slightly different, but the standard in each of these formulations is identical. The state's interest in detecting and preventing crime begins to prevail over the individual's interest in being left alone at the point where credibly based probability replaces suspicion. So for me, that like encapsulates sort of in summary why I think like I fall on that side of the spectrum, whether it's the first step of the investigation or the second. I think that we got to have that credibly based probability over just suspicion. And I think suspicion is just hunch, but, so go ahead.
So my reflections are that he was talking about the law office that was being searched, and so like your home, like I think that language was about those sorts of things. You need to have you need to be doing those intrusive searches with that logic model. Cahill, I don't know how you say that. It's a more recent. Cahill. It's a more recent Supreme Court of Canada case that talks about suspicion, and so you have it right. It is this debate around probability versus possibility, and so again, it's like if it assists you in any way, I mean, it's about the nature of the intrusion. That you really want that higher standard, everything that you read when somebody's in your home, and so but a lower standard does exist in the criminal code, and for all sorts of different investigative techniques. In Cahill, it was using a search, like a sniffer dog on bags. Again, no warrant was required, but they're allowed to use it when they reach the reasonable grounds to suspect. So it is a concept in the criminal law, and it's to be used in less intrusive types of situations. I don't know if you had any reflections that might be able to.
If I may, and Mr. Mantle, I think you've talked about how the common law grows, and it has. So the reasonable suspicion standard has existed in the criminal code since 1993 after another Supreme Court of Canada case in R.V. Wise. And there is also a lot of discourse in that case of how it doesn't necessarily need to be the Hunter-Southam test for certain types of police
Désolé
techniques.
de vous interrompre.
I beg your pardon for interrupting you.
Or Cahill case, if it helps in any way, some of the language is police officer had to have objectively discernible facts before a judge setting out the connection to the criminal activity, more than a mere hunch or an intuition, but less than a probability, a logical connection between the facts and the offense, assess through totality of the circumstances. And here's something that's really important. I think I want to underscore what the officer said, which is, that the police officer may draw on their training and experience. Well, they do that when they're setting out these warrants, which again, what we're talking about as it relates to the subscriber information is still a warrant before a judge. And so based on their training and their experience, those facts may mean different things. So that was something that the Supreme Court of Canada specifically said, is that they rely on that training and that experience in that threshold.
That is helpful, and I agree. I mean, I sort of started at the genesis with the first case, and of course it's evolved, as the common law does. So I take the point that it's not that test anymore. It's a version of that. But even in those cases, it's still cited approvingly as the start. So I like to start at the beginning where we go, and then go to the top and see how it's most recently been considered. So I appreciate your comments there. I guess I would take the difference. Maybe we interpret the facts a little bit different, because I think, in the case you were making the distinction in the Southam case that, you're investigating the place of business or a home that's, obviously attracts a higher threshold. Of course, I agree with that. If you're going into someone's home, that's probably the highest threshold we could establish. But I think increasingly, our activities online in all of their various ways are increasingly become, our digital home, right? And people are participating in society online in a way that they never have before. And I think that we, as parliamentarians, should recognize that, and I think seek to protect the privacy of Canadians online in a similar manner. And sometimes, not all the times, I agree. There's this, some stuff attracts a lower expectation, some attracts a higher expectation. But I think where I disagree with the government on this is that some of the stuff that they're suggesting is, basic information or should attract lower. I'm not sure that it does, and I think over time, only more activities will be taken by Canadians online. More of their life will be online, and the common law needs to accept, to grapple with that, and I hope protect that under charter jurisprudence and common law jurisprudence as well. I have another point I want to make, but I think I'll make it in our discussion of the production order in that. So I just want to ask one more unanimous consent, Mr. Chair, and then I will be done my comments. So like my other comments, we've been talking a lot about the first step here is the ISPs and providers. So I would like you, if you could, to canvass the committee to see if there would be unanimous consent to invite NordVPN to provide testimony on Part 2 of Bill C-22.
Is there unanimous?
No.
Thank you.
You've got to earn unanimous consent. You got to work harder.
So MP Mantle, is it fine to go to MP Kirkland?
One moment. I think the strength of the request should do the work for us, Mr. Ramsey, despite your denial of unanimous consent. I would then like to put that on notice as a motion, Mr. Chair.
Well, MP Mantle, just to be sure that the clerks do the job that they need to do in the manner that you are rightly expecting them to do, if you can provide that in writing, that would be very helpful.
Yes, and I've tried 3 times, so I will send 3 emails for you.
Very good. Thank you so much, Madame Kirkland.
Thank you, Chair. If you will indulge me, Chair, I am absolutely going to mention this amendment, but I received news, and I think this is the appropriate place to mention it in Public Safety Committee. Durham Regional Police in my region just put out a notice about an hour ago. Devastated to hear about the line of duty death of an OPP officer near Hearst, Ontario. And I just wanted to officially extend my condolences to the OPP on the loss of their line of Constable Tarun Bally. And my thoughts and prayers go out to his family, friends, colleagues, and all those affected by the tragic loss. He was a young man who was only serving for a couple of years. So I just felt like public safety was a good place for us to just remember that we do stand with our officers, and when we lose one who's running towards danger when the rest of us are running away from it, it deserves mention.
May I suggest a minute of silence?
I'm fine with that. Yeah, that'd be fine.
Thank you.
Thank you. Thank you.
And as you will note, everyone in this room appreciates your heartfelt condolences, which we would like to share to your community as well.
Thank you. I think it's important for Canadians to see parliamentarians standing together when it comes to that sort of thing. So, excuse my emotions. Back to the matter at hand. In terms of this amendment, can I just say how deeply thankful I am for all of you here? I know it's been a long time, and we're asking very in-depth, very, very crucial questions. And what I'm really thankful for is just how much attention you have paid. You know, you've been actively listening to all of our questions and concerns, and that means a lot to me personally as we delve through this. And you know, I feel somewhat disappointed. It feels like, you know, some members come to the committee with decisions already made, and I feel somewhat disappointed that, you know, the questions that are being posed and answered aren't being closely listened to as well as you all are listening to our questions, so that we can make informed decisions about these amendments. It's important to me that we make informed decisions on the amendments. So I will say that you know, Ms. Gibner, I appreciate your help in all of this. You've helped clarify a lot of things for me. You did mention in terms of, you know, when something is less intrusive, you know, the threshold of suspect versus believe is acceptable. And I'm with you on that to a point. If I didn't feel like all of the amendments that we're going to put forward for Part 1 and Part 2 weren't, if the amendments to qualify language that we have, you know, upcoming and that has already passed, quite frankly, when we want to qualify and clarify language to be namely versus including, for instance, like the last amendment we looked at, you know, being very careful to limit what do you mean by subscriber information. If we're not, and it seems like in general, at least the Liberal members on our committee aren't willing to, you know, specifically name and qualify so that we can get just simply more specific. We might be more willing to accept reasonable threshold, like the threshold of suspect, right? If we understood what exactly it was. Now, I understand with this one, it's specifically in terms of not subscriber information, but what's the wording? Sorry, I'm losing my train of thought. It's just to find out whether or not they're a subscriber, right? Just yes or no, whether or not, right? Confirmation of service. Thank you. It's been a long day, and I realize I'm going till midnight tonight, so it's going to be a lot longer. I guess my question is this: if the committee were to accept this amendment, and I think I'd like to hear from all of you on this, if I can. So, CSIS, Department of Justice, Public Safety, and obviously RCMP as well. So I guess it's 4 organizations, but. If the committee were to adopt this amendment, okay, to make it believe versus suspect, would there be a problem with that? And what would it be? I'll start if I may, and I would say that the tool would not assist police the way it was designed, because what you heard the officer say was, I have no idea who the service provider is. That's the point. I don't know. I'm at the start of my investigation, and I need to know where to start. And so, like that it's not possible. Like it's impossible to reach that threshold. So it doesn't go anywhere. Is what I heard him say. And so that's why I would say that the tool wouldn't be. I think you've heard my friend say that it would just sort of be back to the drawing board. They would be sort of in the same sort of general production order world where they already have to meet reasonable and probable grounds. And I'll go to everyone else, sorry, but you've actually made me wonder another question. So essentially, you're saying that you don't know whether to go further in an investigation. You have a suspicion, right? Not sure whether to move forward, and perhaps RCMP and CSIS should get in on this too. You're not sure whether you should proceed with an investigation until you know
if the confirmation of service? Or would that even make a difference? You know already whether or not you want to proceed with an investigation.
IP address was one of the examples that was used. I think they said, I have an IP address, but I don't have reasonable probable grounds that it's Rogers who holds it. I don't actually know who it is associated with.
And so finding out that it's Rogers,
right,
then does what? Then you get the production order to
then
find out.
that allows them to go to court, because of course the court order says you need to know who holds the information to get in the door. Yeah.
All of the, okay, that is making sense to me. Thank you. I appreciate your thoughts on that. Who else? Who would like to go next? Thank you, Ms. Heigl.
Happy to chime in here just because we've been part of working with the RCMP and CSIS and challenge functioning and trying to pressure test what the concepts that we're talking about today that are in the bill. So I think for us, we really saw this as a building block. It is the first block, and I think my colleague here has done a great job of explaining how this is. We saw this very much as a yes or no, and therefore, with the ground of suspicion, that makes sense if, say, we get, and we, I mean, the royal we, I suppose, it could be from any side, but certainly from law enforcement, when the U.S., and I won't get the acronym proper, but their Child Sexual Exploitation Center, who has greater flexibility within the investigative space, provides the RCMP's unit with an IP address, it's literally put on the shelf right now. So back to the numbers and the stats that Ms. Gibner gave, this would at least allow us that first crumb in order to figure out who, in fact, the IP address belongs to. And the building block of that investigation in its totality has to be presented in a court in order to have somebody charged and prosecuted. And all of that information would be put bare for all of the public to see. So for us, in the collection of all of that information and all of the steps that both of my colleagues have spoke eloquently to, I think it certainly gave us pause and gave enough of a rationale to encourage that it be put forward to the table for consideration.
Okay. Anything to add? Makes sense? You're good?
Yeah, maybe just quickly. So our kind of bread and butter investigative authority is our Section 12 in the CSIS Act, which is at RGS, reasonable grounds to suspect. So a Section 12 investigation, obviously we've got to have RGS that there's a threat to the security of Canada. Again, not to get too technical, but Section 2 of the CSIS Act lays that out broadly. Espionage and sabotage, foreign influence, terrorism, essentially, and then subversion. Those are kind of the four broad definitions that we would be looking at. There's an additional, on our side, an additional, let's call it safeguard, which is strictly necessary. So to avoid kind of what's been deemed here sort of fishing expeditions, not just a resource question, but from an authority's perspective, we can only collect and retain information that is strictly necessary to advance an investigation for us at that RGS level and pinned to sort of section 2 of our act. So hopefully that helps. So this is an additional tool at the same standard that would allow us, as we've sort of talked about, to get one of those very first steps to be able to say, you know, there's a phone number that we think is involved in, let's say, a terrorism case. We need to be able to determine which provider, whether that's Rogers, TELUS, Bell, somebody else, owns that phone number, so that we can then come back with that higher level of authorization, which again is coming from judicial authorization.
So just to clarify, for confirmation of service, let's say in that example you have your phone number. You have a phone number, but you don't have a name attached to that phone number. So when you're getting confirmation of service, you go to, you know, Rogers, let's say, and say, is this phone number? You said it was a yes/no question, but are they also providing the name then of that person?
No. We come back with judicial authorization to get name and address and that more invasive set of information, let's say.
Oh gosh, I feel like that's the clearest thing I've heard all night. That's great. And it's not because you all haven't been clear. It is that there's people are having a hard time understanding it, and my background is in education. I've said that before, so I like to bring things down to a level, that everyone can really grasp sort of what's going on here. Because I honestly have less of a problem in this one particular spot to have suspicion versus belief. I do think that it's a problem in other places, but if it's just literally a yes, no, and then a production order to find out name and that sort of thing, I can sort of get behind it. But as I said, my reticence comes. Right, my hesitation comes is with all of the rest of the amendments. If we're not willing to qualify and name and clearly define some of the terms we're using in this bill, if the government members aren't willing to help us get those amendments through to really clearly qualify that, that's when this type of amendment I'd be more sort of in support of. Not to say whether I would or wouldn't, but I'd have to hear a little bit more from other colleagues who know much more about these particular things than I do, like Mr. Mantle, who he's the one with the book sitting beside him, right? So he knows some of that more information, but that is very helpful to me, and I appreciate it very much. The only other thing I'll comment on, as someone sort of said on the other side, Mr. Mantle, you have to earn unanimous consent. Someone sort of said that on the other side, and I would argue that it honestly wouldn't matter whether we earned it or not, whether the argument was made or not. I am convinced that the members on the other side would block and deny all of our wishes for consent, like they did with mine with the Privacy Commissioner. I would like to say that I would like to reiterate as I close. I would like to reiterate as I close that Conservatives are committed to helping law enforcement. We are committed to getting through. I personally would like us. I've said this before. I put a notice of motion. Whether or not we'll be able to get there in terms of splitting this bill, because I truly believe if we can move along and get Part 1 passed, then I'm sorry, I'm having a hard time concentrating because there's so much talking on the other side. But if we can move along on getting Part 1 passed, then we could all get. We're on the same page there with some minor amendments, but it's not feeling like that there's any willingness to sort of move on it, which does make me nervous as a member of the opposition as I try to do my due diligence and my job as not only my constituents but Canadians expect me to. So I'll end with that and thank everyone on this committee for the moment of time they spent in remembering the officer who passed away today in the line of duty. And I will leave it there. Thank you, Chair.
Thank you, Madam Kirkland. MP Al.
Now, early on, I asked questions about the estimate of the number of times that you may use this new measure if it's being adopted. And also, I asked about the impact of not having this measure or this tool in your hands in the past. And, I was given that there's no concrete information. However, I want to draw your attention to a piece of information. It was a report completed by the National Security and Intelligence Committee in 2025. The name of the report is Special Report on the Lawful Access to Communication by Security and Intelligence Organizations. So as I mentioned, this report is as recent as 2025. And on page 54 of that report, some information are very interesting, and I would say is relevant to what we are talking about here. And I would read it out for you. The committee did not see, the National Security and Intelligence Committee, the committee did not see any clear empirical data to substantiate claims by Canada's security and intelligence organizations that they face serious lawful access challenges because of rapid evolving technologies. CSIS and RCMP do not systematically track how often they encounter various technological challenges in their national security investigations. And further on, it said, as a result, they do not know in quantifiable terms the degree of impact and overall significance of these challenges. Going further down, it said, this is an important omission because as these organizations advise the government and attempt to convince Canadians, particularly those concerned about the potential erosion of their privacy, that new legislation and resources are required to keep pace with evolving technology. So I will ask for comments and feedback. Any response to that piece of information?
I mean, so the NSI COP report that you reference to, what we refer to as the Going Dark report, has a number of findings in there in terms of just lawful access and the need for lawful access. I think, as you heard today from some of the witnesses, it is difficult to track because there's RCMP, police of jurisdiction as well have some of these requests. Obviously, I think it goes without saying that if we were able to track every single instance where we tried to get, or law enforcement tried to get information, that would be helpful. Obviously, NSI COP found that we didn't, the law enforcement and CSIS didn't do that. I'm not sure what else we can say. I think we can rely, however, on the experience that CSIS and RCMP have had and over the years and what they've shared with us, what they also shared with the NSI COP. The information that was shared with NSI COP still led the NSI COP to conclude that lawful access reform was necessary.
Any other comments?
Maybe just one other comment to add. That was one of the reasons I got that data for you, just to highlight some stats that I was able to get at my fingertips if it assisted you, just in terms of the thousands of investigations that were not closed as a result of not having these basic tools.
Well, Mr. Chair, I just want to go back to the point I made earlier today. I'm trying to, I mean, we all are, right, trying to find a balance. And that's why we have to listen to both sides. So yes, come here to advocate, for additional tools that you can use. I appreciate that. I understand that. But on the other hand, we also have the duty to try to strike a balance to protect the privacy of Canadians. But from this report, it has come to the conclusion there's no substantial evidence to back up the claim that there's a serious lawful access challenge. So I think that's something we have to bear in mind. I'm not saying that this is, I'm not saying that you do not require further measures. However, again, going back to how we can strike the balance, as I said before, I think the loosely defined meaning of reasonable grounds to suspect and asking for the power to use it, I tend to feel that the net is too wide. The risk is too big, and also the temptation to use it is also to abuse it is big. So I would say that I still have hesitation to support the draft as it is right now. Yep, that's it.
Don't worry, I'm back.
Oh, OK, surprise, surprise. OK, bon, très bien. Écoutez, une bonne nouvelle.
Very well. Well, look, that's good news.
Didn't want to disappoint Mr. Ramsey here, so. I just wanted to return to one question on, you've in my view, you've been making your case why you want to change the threshold or the standard. Sorry, did you want to put your hand up and go on record, or? Well, you are, though, because I can hear you, and you're, okay. Okay, well, would you like to put that on the record? Okay, good, I'm glad it is. I'm glad it is. All right. I would disagree with that characterization entirely. Sorry, not entirely, in part, is what I meant. But my question is, in my view, you've been establishing why you think, you made a conscious choice to lower the threshold, why you think that will give you more tools. I want to ask, and I'll start with public safety, did you turn your mind to or analyze potential deleterious effects of lowering the standard?
Deleterious.
So you've suggested what you think the benefit will be, which is some quicker access to this information. Did you consider downside risks to lowering the standard? With respect to the confirmation of service, which is what we're discussing now.
So I think it goes with, it's a consult that we obviously work very closely with our justice colleagues on this particular element, but I would argue that yes, absolutely. Pros and cons are always weighed in considerations of, we even think of it also from a resourcing perspective, for law enforcement. They're not just going to be in the position to then start firing out, yes or no. It has to be led by something of suspicion, getting a tidbit of information. So I think and when we weigh out everything, that's what we end up with as our recommendation. So I guess maybe a little bit more to our justice colleagues around the negative impact from that from a court process perspective.
Thanks for the question. I would just go back to what Chief Superintendent Burchill said too, just about in terms of investigations. This information, probably in close to the majority of situations, is given voluntarily currently. So the confirmation of service demand is a stopgap for those service providers that require the piece of paper so that they have something to respond to protect them from liability. So in terms of the deleterious effects, this is already being done. So this is part of routine police work. And as I think Sergeant Gilk said, it's a requirement to know who the service provider is before you actually go to court and get a production order against that service provider.
If I could just add, because what I'm hearing you say is more the safeguards, and so what I like, if it helps you think through the calibration and the safeguards and the tool, just remind you that the telcos have the ability not to respond, and so there's that safeguard. Of course, they can judicially review a decision both on the confirmation of service demand or any of the warrant provisions, including the new production warrant. So there's judicial oversight into everything that's provided for in the code.
Thank you for that. I think my question might be a little bit more germane to the production order when we get to that and the implications of lowering the standard in the production order and how that might interplay with the admissibility of evidence obtained through a lower standard. Also, I think we'll have another discussion about the judicial oversight up to and including judicial review, because that's the very last step on some of this. There's other provisions that I'm sure we'll explore in different parts of the bill. Okay, but thank you.
Très bien, merci beaucoup.
Very good. Thank you very much. And now this brings us to the question, is the amendment NDP 2 carried? On division?
It took me a moment to get my point of order. I'm sorry, could you repeat? It took me a moment to get my
Je vais répéter avec plaisir.
Yes, I will repeat it with pleasure. Is NDP 2 carried? Is NDP 2 carried?
Un vote avec appel nominal.
Yes, a recorded division, if you please, Mr. Clerk.
Monsieur Ramsey?
No.
Mr. Housefather?
No.
Miss Akan?
No.
Madame Desrochers?
No.
Madame Dondurand?
No.
Miss Saudi?
No.
Mr. Frank?
Yes.
Mr. Mantle? Yes. Miss Kirkland?
Yes.
Mr. Au?
Yes.
Madame de Bellefeuille?
No.
Mr. Chair? Nays contre? 7. Yeas pour? 4, 4.
Merci. L'amendement est donc.
Thank you. The amendment is therefore defeated. Is Clause 5 carried? Clause 5 is carried on division. With a recorded vote, please.
Monsieur Ramsey?
Oui.
Mr. Housefather?
Yes.
Miss Akan?
Yes.
Madame Desrochers?
Oui.
Madame Dondurand?
Oui.
Miss Saudi?
Yep.
Mr. Capito?
Oh, got to pass. Yes.
Mr. Mantle? No. Miss Kirkland?
Yes.
Mr. Au?
Yes.
Madame de Bellefeuille?
Oh.
Mr. Chair, yeas pour 10, 10, nays contre 1, 1.
Merci. L'article.
Thank you. Clause 5 is therefore carried, which brings us to Clause 6. And Amendment NDP 3 is deemed to have been moved. And if NDP 3 is carried, BQ 4 will not be able to be moved because there is a line conflict.
Want to present your amendment?
Thank you very much, Mr. Chair. So this is on NDP 3. Sorry, I'm just going to fix my screen here. So with respect to this amendment, the NDP has received comments from prominent lawyers, legal professors, and so on, concerned about the impact on privacy and constitutional rights of Canada related to this bill. And they say that, and I quote, as affirmed by the Supreme Court of Canada's decision in R versus Spencer, Canadians have a strong privacy interest in anonymity online. The existing general protection order available since 2004, readily obtained by telewarrant, or it gives police an effective tool to link an IP address or phone number to a named subscriber and requires them to establish reasonable grounds to believe that an offense has been committed. Bill C-22 creates a new dedicated subscriber information order that reduces that standard to reasonable grounds to suspect. The courts have held that this distinction is not semantic. In R versus West, the Ontario Court of Appeal excluded evidence obtained through a production order precisely because the officer had established only grounds to suspect rather grounds to believe. The scope of disclosure under the new order is a further concern. Although the definition of subscriber information has been narrowed compared to Bill C-2, the order still allows for for production of a broad scope of information, including the types of services provided
Pardon,
and the
Madame Kwan,
identifiers.
je suppose que
Mr. Bellefeuille, Ms. Kwan is reading quickly, and we're wondering if the text is available for interpreters. The interpreter has noted that the text was not provided. Is it possible to provide it since it is a legal text being read quickly?
share with the interpreter. If not, then it may be a good idea just to slow down a little bit the pace so the interpreters can follow you, Ms. Kwan.
Sure. My apologies. I will slow it down. I think my staff has gone home for the day, so I won't be able to get them to send it to the interpreters. I will start at the beginning of this first sentence and go slower. The scope of disclosure under the new order is a further concern. Although the definition of subscriber information has been narrowed compared to Bill C-2, the order still allows for production of a broad scope of information, including the types of services provided and the identifiers of every device associated with the account. This goes well beyond what is needed to connect a name to an IP address. It can be directed to a physician, a cable company, or platform like iCloud, requiring disclosure of what cable packages a person subscribes to, what medical services they receive, or what devices they use. And much of this information carries a high privacy interest and calls for a higher legal standard. If Parliament seeks to create a subscriber information order that can withstand scrutiny under Section 8 of the Charter, it should narrow the scope to basic identifying information, name, address, and the specific account identifier in question, and raise the threshold to reasonable grounds to believe. So to that end, they also note that including analogous powers in the Canadian Security Intelligence Service Act, the CSIS Act, raises even greater issues. Unlike criminal defendants, persons of interest to CSIS are never given an opportunity in court to challenge the intrusion of state power into their private lives. The Charter concerns are more acute with CSIS, and the service should have to satisfy a reasonable grounds to believe threshold for all of these authorities. So this amendment would narrow the scope to basic identifying information, name, address, and the specific account identifier in question, and raise the threshold to reasonable grounds to believe to withstand scrutiny under Section 8 of the Charter.
Thank you, Madame Kwan. Monsieur le député Ramsey.
Thank you, Ms. Kwan. Mr. Ramsey. I thank my colleague for tabling these amendments. We intend to vote against the amendment simply because the production order, when it comes to the production order, we think the judge is the most appropriate person to communicate what needs to be done in this case. Thank you. Does Amendment NDP 3, MP Caputo?
If I could hear from the officials on this one. In your eyes, what is the practical implication or impact of this amendment, please?
Thank you for the question. The practical implication of this amendment would create a conflict between the definition that was just passed in the definition section in, I believe, clause 2 or 3, and this provision. So the production order for subscriber information as drafted in the NDP motion would disregard the subscriber information definition.
Okay, I'm sorry, I don't have, I have to look at the bill to get that. Can you, when you say it created discrepancy, what precisely is the discrepancy? Because we may wish to move a sub-amendment to ameliorate that, that discrepancy, and is that possible?
I don't know if it's possible for me. I don't know if I have the technology. I'm I think, looking at the same thing you are, which is the motion. So you have to look at the motion in concert with the bill to see how it works. There's another thing that the motion does too, is that it includes transmission data in here, which is not supposed to be included in the subscriber information production order. So it removes the give and take. It's supposed to relate to information that's been provided by the police or that's been stipulated in the affidavit that will form part of the order to be served on the service provider.
Okay, I think I missed that. Can you take me through that a little bit more, Mr. Wong, when you say the give and take and it's got something in here that shouldn't be in here? When you say it shouldn't be in here, it's introducing a novel concept or novel wording? Because, I mean, if there's something that like inadvertently isn't in here, the committee can amend that in order to make it appropriate. Like if it's a drafting error, I guess, is the question.
Thank you again. If we look at the original wording of the provision for where this is supposed to take place, so it's to produce a document containing all the subscriber information that relates to any information. What's been removed is that relates to any information. So this is what the police have provided in their affidavit that will be spelled out in the order. So that omission means that the service provider isn't responding to specific information that's been provided through the affidavit. So it's sort of dismantling how the production order works.
Is it workable? Like when I get it's dismantling and it is changing how it's drafted, but is it not still workable in the way that Ms. Kwan's amendment and frankly CPC 3 is the same amendment is drafted? Is it not still workable?
Thank you again. I think CPC's amendment varies slightly because it refers to subscriber information, whereas the NDP motion does not refer to subscriber information. It says that relates to a subscriber. So the NDP motion completely avoids the definition of subscriber information, whereas the CPC motion and the block motion refer to subscriber information. But it's the tail end, and from a practical perspective, I think there's arguments that can be made that that it would still work out in the way that it was designed to work out, but it is less clear. The way that it's spelled out in the bill version is that it does provide the service provider something to respond to, and that is the information that has been provided in the affidavit.
Okay, so in your view, the conservative CPC 3 and BQ4 are actually workable, but the NDP motion at this point is not workable. Is that accurate?
I would say, I don't know how to respond to that. I would say both have issues with them, but as you said, from a practical perspective, the CPC and BQ motion might still work, just perhaps not work in the way that it's intended because there's a lack of clarity there now.
Okay, well, I think then the appropriate thing would be to move on to BQ4 and then ask our questions on BQ4 if that's the case. So I don't have any further interventions, but my colleagues may.
Merci, député Mantle.
Thank you, Mr. Mantle.
Just to say, I note the difference in BQ4 and CPC 3 from NDP 3, and I see what you're saying. So I would agree maybe the BQ amendment or ours is a better place to have this discussion.
Did I miss something? OK, good. Merci. Alors,
Thank you. So, does amendment NDP 3 carry?
donc l'amendement NDP.
So, amendment NDP 3 is defeated, which brings us to BQ4. Do you move the amendment, Madame de Bellefeuille? Yes, Mr. Chair. This amendment is also a recommendation by the Privacy Commissioner. And Mr. Chair, here's what he wants. He wants much more information to be able to be communicated to during an investigation. He says that certain information is allowed to be collected, but there's also certain restriction. So I feel that this recommendation is reasonable, and I hope I will receive my colleagues' support for the amendment. Thank you, Ms. de Bellefeuille. Before I give the floor to Mr. Housefather, I would like to note that since BQ4 has been moved, CPC3 cannot be moved because they are identical. Mr. Housefather. Thank you, Mr. Chair, and thank you, Madame de Bellefeuille. I would like to suggest a sub-amendment to BQ4. It has been sent to everyone's inbox. So I will read this. So I would propose that motion BQ4, proposing to amend Clause 6 of Bill C-22, be amended by A, substituting for the reference replacing lines 21 to 23 in the opening portion, the reference replacing lines 21 to 24. B, substituting the following for the text proposed by the motion. Produce a document containing the subscriber information referred to in any of paragraphs A to C of the definition subscriber information in section 487.011, point 011. That is A, specified by the justice or judge in the order. B, relates to any information including transmission data that is specified in the order. And C, that is in the person's possession or control when they receive the order. And Mr. Chair, if I may, I would like to explain, but I would like to first ensure that all colleagues do have a copy before I begin.
Bonne question.
Good question. Does everyone have access to the sub-amendment that has been moved by MP Housefather?
Qui a été envoyé il y a quelques...
Which has been sent out by the clerk. The clerk circulated that sub-amendment earlier, very recently, and if you have access to your email inbox, you should be able to see it. Mr. Mantle.
Yeah, I just received it in my inbox. Can we just have 2 minutes to read it here in English? Thank you.
Please, the House Father. Okay. So, okay, we can do that. And, okay, 5 minutes pour vous.
Okay, 5 minutes for you.
While you do that, MP Housefather, would you like to expand furthermore on that sub-amendment? Why?
Je peux, Monsieur le Président, mais je crois que...
I certainly can, Mr. Chair, but I thought my colleague wanted to read it, to have some time just to read it. Very well, that's what we'll do. We'll suspend for 2 minutes to give everyone a chance to read the sub-amendment carefully. We will resume in just a few moments because given that the clock is ticking and our resources are limited, we have been giving some of our colleagues a chance to read the sub-amendment, but we will adjourn now and come back on Thursday. So thank you and have a good evening.